of testimony and admissions. And so to the extent that
which one are you taking up first? I've heard two different.
my understanding is that the requests for admissions were going to be read. If the requests for admissions are read, consistent with what Ms. Douglas just stated to the court, then the deposition testimony becomes moot and cumulative and therefore inadmissible under 2403, regardless of the procedural appropriateness of doing so. Also, the deposition testimony that's been designated, at least a portion of it, is cumulative to the testimony of Ms. Werner yesterday when she was on the witness stand. And so, in the same way that if the witness was on the stand for however long and we would object and say asked and answered cumulative, the same applies here in this context. And so, it might be helpful, Ms. Douglas and the defense counsel were able to provide me RFAs and the deposition transcript. I'm happy to proffer them to the court so that the court can compare them. In essence, we're not objecting to say you can't do either or both. We're saying pick one. If you're going to read the request for admissions, read the request for admissions, and then the deposition becomes duplicative. If you're going to read the deposition transcript, there's a portion of it that's repetitive as to what happened yesterday, but the rest of it, if it wasn't asked yesterday, is fine. But then you can't come back and read the request for admissions.
Okay. Are these agreed upon what you're planning on doing so that I can read these?
Yes, Your Honor.
Okay.
Again, we designated this testimony. There was no objection until today.
All right, I'll take a look at that. All right, so I've got 4 responses flagged. Is that correct, Ms. Douglas?
Yes, Your Honor.
All right. And how did you propose to play the deposition?
Yes, Your Honor. Just play the clips of the deposition in our case.
All right. I'm going to overrule the objection. They're obviously taken at different times and done at different times, and I'm going to allow them to do both. All right. Any other objections to take up outside the presence of the jury?
Apparently, there's an objection to our first witness, Dr. Lee Hagan. He was designated. There was no objection to his testimony in real time. Motions in limine came and went. There was no motion in limine made with respect to Dr. Hagan until today. Mr. Hogan will argue that. He argued all of the expert issues at the motion in limine hearing, so he will present argument on that with respect to Dr. Hagan.
Before we proceed with that, did we start a court or joint exhibit number or list yet?
We were doing letters.
We were doing letters for the court, that's right. All right, so these two, just for the record, that were handed up, the request for admissions and deposition transcript would be? What's that? D and E. All right, D will be the request for admissions for the record. E will be the deposition transcript. Thank you very much. All right, so you are planning on calling Dr. Higgins live, is that correct?
Yes, Your Honor.
All right, and the objections?
Yes, Your Honor. This is in real time. This is when he's called, so there isn't any issue of waiver as seems to be implied by defense counsel. The issue here is quite a simple one, in my view, Your Honor, in terms of the precedent, which is that an expert cannot be called to testify as to the credibility or the weight of another expert. The expert under 702, 703 has to provide some opinion testimony that is scientific, technical, or otherwise, and that is helpful to the trier of fact in deciding a material issue in dispute. Dr. Hagan, a psychologist, has not been proffered or designated to address an issue in dispute amongst the parties What he's been proffered to testify to is whether or not Dr. Watson, who is plaintiff's psychiatrist, credibly conducted an evaluation of Miss Werner. And there's a case on point that I've provided to opposing counsel, and I have a copy for the court if it might be helpful. And this is the Brown versus Corbin case in 1992. May I approach, Your Honor?
And just to, as you said, that this was in real time, meaning that this was not subject to any of the pretrial motion filings.
Correct.
All right, Ms. Douglas, you agree? Okay.
Yeah, it was not subject to, really, this was sort of the first news we heard about this.
I alerted opposing counsel of the objection last week. And I've highlighted a portion on page 5 of that opinion, Your Honor.
All right, so what was the testimony that was not permitted in this case?
The testimony in that case is that Mr. Tuning, who is a accident reconstructionist in the Richmond area, had been proffered to essentially discuss the principles or concepts of accident reconstruction. So here are the types of things that are reliable, here's the types of things that an accident reconstructionist ought to do, and then his opinion in that case was effectively, I can't come to an opinion because there isn't sufficient information for me as an accident reconstructionist to come to an opinion. And the court in that case said, both in that paragraph and above, that in fact doesn't even qualify as a conclusion or an opinion. Saying that I didn't or I can't come to an opinion isn't itself an opinion. It's not an opinion of technical or scientific or any specialized fact. And so effectively what it was offered to do, as is argued by Corbin, which was the proponent of Mr. Tuning's testimony in that case, was to attack, as it says in that paragraph, Dickinson's credibility and the validity of Dixon's investigation, and therefore properly responded to Dixon's testimony. In other words, we think that Dixon, in this case, didn't conduct an appropriate investigation, and therefore we're going to offer Tuning to say what an appropriate investigation is, so that can rebut or discredit the testimony of Dixon. It's exactly what it's being offered for in this case. The opinions, if we look at the actual report of Dr. Hagen,
Let me get to that. And then also let me find the designation. Now, was there anything in their designation of him that goes to this issue that you're concerned with?
The designation of Hagen is non-substantive in my view, Your Honor. It's kind of a 2 or 3 paragraph thing that just says he created a report, see the report.
All right, go ahead.
And so when we look at his report, there's a section 4 on his report. It's a 22-page report, and the section starts with a heading that says opinions and their bases.
What page number is that?
It says page 3 of 22 in the top left-hand corner of his.
All right.
And so within that, opinion 1, broad opinion 1, says the practice standards for mental health professionals functioning in a forensic capacity are applicable to Dr. Watson's undertaking in the index case. So effectively, the first opinion is, here are all the things that we think Dr. Watson was obligated to do. And to our point, Your Honor, it's exactly what the Brown case says is impermissible. You're effectively saying, here's what I think this expert should have, or the standards that should apply to him, similar to Tuning saying, here are the types of things an accident reconstructionist needs to consider. And so when we look at those within the context, there's citing to psychiatric manuals, there's citing to different objectivity and diligence requirements, and all of that's fine, but it's not helpful here because ultimately it doesn't render an opinion or conclusion as to the applicability of any of that, other than to say, I think that Dr. Watson should have done these things. So then opinion 2 which is on page 5, top of page 5, says the information cited in Dr. Watson's report and assessment methods and the records and the treater's therapy notes are not sufficient to support all of their conclusions. Again, I think this is essentially what I anticipate the testimony of Dr. Hagen being. I don't think that Dr. Watson had enough information to render the opinions that he did. And that is precisely what invades the province of the jury. It is the jury's job to assess the credibility of the witnesses. That's actually one of the agreed instructions that the parties have agreed to. It's also an agreed instruction that the parties have agreed to, as was submitted to the court, that here are the ways in which you measure or assess an expert's testimony. And one expert critiquing another expert is not the permissible standard within the evidentiary rules. That invades the province of the jury. And that's, he goes on for 3 pages about the different types of things that he ought to think or wishes or thinks that should have been considered by Dr. Watson. And as a little anecdote, Your Honor, the rules as it relates to expert testimony do not permit the recitation of hearsay or inadmissible evidence. So if this witness goes on the stand, effectively the question is, what's your opinion? And the opinion is, I don't think Dr. Watson had enough information to render his opinions. And the question becomes, okay, what does that do other than assess the credibility of the witness, which is exactly what the jury's job is, and that would invade their province. And then opinion 3, which is on page 15, which says, again, an opinion focused on Dr. Watson. Dr. Watson's report and assessment methods demonstrate complications when relying on a psychological diagnosis to prove a legal fact. So critiquing the weight or the validity or the credibility that the jury should provide to his testimony. Now, this is an issue that comes up, this is an issue that we've dealt with in Richmond before, in which there's an expert that comes in and says, this was Dr. Ziv in a different case, just anecdotally, Your Honor. I think that this expert did a good job in the process. I think this expert did a bad job in the process. And then the question is to the expert themselves, Dr. Ziv in that context, well, what did you do to assess the material issue in dispute? What did you do to assess causation? What did you do to assess damages? What did you do to actually become helpful to the trier of fact on an issue that they need to decide? And the answer is nothing. They didn't evaluate. Dr. Hagen didn't evaluate Ms. Werner. Dr. Hagen doesn't even opine as to causality or diagnoses of Mrs. Werner. All he's offered to show or to testify to is, I don't think I agree with what Dr. Watson says, effectively. And then the question is, why do we need that? How is that helpful to the trier of fact, other than to assess the credibility of an expert witness, which the Supreme Court has said unequivocally is impermissible?
All right, your responses?
Yes, Your Honor. In brief, what our response amounts to is the argument that there's a distinction in the law between opining directly or indirectly on whether or not a specific witness is credible and their testimony is credible, on the one hand, versus offering scientific or other professional expert testimony to assist the trier of fact in assessing and weighing the credibility of that witness's testimony based on their factual basis for arriving at their conclusions, based on the way they conducted their analysis. That is fodder for the jury to determine. That does not usurp the province of the jury for its quintessential fact-finding function. How do we know this? We know this because, number one, under Rule 2702 of the Rules of Evidence of Virginia, subsection B, it does state clearly that, quote, testimony that is speculative or which opines on the credibility of another witness is not admissible. The key language there is which opines on the credibility of another witness. Dr. Hagen is not going to opine on the credibility of Dr. Watson. What would happen is the crux and thrust of his testimony is establishing that these are the proper protocols and factors that a clinician would rely upon in reaching an assessment. And that is something that the jury needs to hear about to assess and weigh whether or not to assign what weight to give to Dr. Watson's testimony. It falls short of going over and pointing to Dr. Watson and saying, this particular expert lacked an adequate factual basis to support their conclusions, therefore you should disregard it. We can offer a step short of that by testifying, here is what a reasonable clinician would rely upon. This is what you need to rely upon. If you do not do this, then you do not have an adequate factual basis. Then it would be left to the jury to assess whether or not, it would be left to argument of counsel to go in closing and say, look, you've heard testimony from Dr. Hagen that these are the principles and standards you need to rely upon in order to conduct a thorough and proper assessment. This wasn't done here. You heard nothing about that with respect to Dr. Watson. In that case, Judge, there is no running afoul of 2702 subsection B. There is no directly identifying this specific witness. You should or should not believe their testimony. That is the problem that these rules are oriented to address. This is also highlighted by the fact that, Judge, there's literally a jury instruction that will be offered in this case on what the jury should consider when they're weighing expert testimony. And this is a model instruction. It's not something crafted by counsel. If you look at Virginia Model Jury Instruction number 2.040, expert witnesses, that provides, Judge, that in considering the weight to be given to the testimony of an expert witness, you should consider the basis for the expert's opinion and the manner by which he or she arrived at it, and the underlying facts and data upon which the expert relied. That's what counsel is referring to when they're saying this is up to the jury to assess and weigh the credibility of this witness. And what's crucial to making that decision, what's crucial information for the jury to assign proper weight to an expert's testimony is the basis for arriving at their conclusions. That is something that is legitimate game, that is fair game for an expert to opine and give an opinion on for the jury. The jury doesn't know what proper protocols the clinician should follow, or the standards it should apply, or the things that they should do or do not do in assessing and reaching an opinion regarding a diagnosis. They don't know that, and that will assist the finder of fact in weighing that expert's testimony. It could potentially be a step too far to say, look, this expert, in my opinion, did not have an adequate factual basis. I would argue that that's fair game as well. But to the extent that there's any concern in that respect of usurping the province of the jury, we can fall short of that. We need not go that far, Judge. And in fact, we can provide a cautionary instruction, and this jury instruction itself will be offered and say, this is your decision, jury. You assess the credibility of witnesses. That completely mitigates any risk that counsel has raised here. Finally, Judge, I apologize to not prepare case law to pass up to the court. I had to do this on the fly. But I've reviewed Corbin, and here's a key distinction here to emphasize. On page 6, the court emphasized, quote, that the expert at issue, his testimony did not offer scientific opinions to assist the jury in resolving certain factual issues. Instead, it suggested by implication that Dixon's investigation was inadequate and that his testimony was not credible. The crucial language there is that the expert did not offer any scientific opinions to assist the jury. This is something where the distinction here is that Dr. Hagen wouldn't be offering opinions. He would also be offering testimony to establish here are the steps that the clinician needs to apply in arriving at a proper diagnosis. I leave it to you, members of the jury, to determine whether or not his testimony is credible. This is borne out in the case law. There's an example in Faust versus Commonwealth. That's 2024 VAF Lexus 111 from March 5th, 2024. The facts are not analogous, but it stands for the principle that in each of these cases where they deal with this particular issue upon which counsel is relying, the court has always emphasized, when they affirm allowing this type of testimony, they have always emphasized that the expert did not opine either directly or indirectly on a specific witness's veracity or credibility. That's all that the rule contemplates. So, Judge, I ask that you admit this evidence. We can issue proper limiting instructions, but the proper remedy is not exclusion.
And obviously, you're not going to be permitted to ask those questions to your witness, right? In terms of his reliability, in terms of his opinion of Dr. Watson's reliability.
Correct.
Okay. All right. Anything else you wanted to put on the record?
Yes, Judge. If they cannot ask those exact questions, what I think we're all acknowledging is the language of 702B, which says that you cannot opine as to the credibility of the other witness, is what is prohibited. But the reason that the case that's been provided to the court is important is that the court says because there is no opinion, the only thing they are doing by implication is attacking the credibility of another witness. That's the only purpose. And when we assess the, when we look at the evidentiary rules and we say, okay, it's satisfied 702, hypothetically, because we're not offering an opinion, they're backtracking as it relates to the designation now. What we then have to question is then, okay, does it survive 403? And the 403 question is there going to be an unfair prejudice, or is the jury, in other words, going to take this testimony and use it for an improper purpose? The improper purpose being exactly what Rule 702 prohibits it from doing. And that's what argument of counsel demonstrated. They essentially said, well, we're not going to get to the credibility question exactly, but we're going to ask everything else up until that question, and then in closing argument, we are going to argue that because of what our expert said, they should discredit what their expert said. And so effectively, it's a roundabout way to get to what is prohibited in 702. And if it's prohibited in 702, and that's the reason they're doing it, that is the precise unfair prejudice that 403 seeks to exclude, which is to say you cannot admit something for one reason and then try to argue it for a separate reason in front of the jury, because you're effectively asking them to take a piece of evidence and use it for an impermissible purpose, which is in and of itself unfair prejudice. And there are cases that discuss the possibility of doing this, and I think Ms. Douglas talked about in conferral that Dr. Hagen does this in Virginia Beach. Well, the rule explicitly discusses the difference between criminal proceedings and civil proceedings in this context. 702A2 talks about how in a criminal proceeding, the expert may be, the court finds that the subject matter is beyond the knowledge and experience of ordinary persons, such that the jury needs expert opinion in order to comprehend the subject matter, form an intelligent opinion, and draw its conclusions. It's permissible in criminal cases. That precise language, which is what they're arguing here, is not in the civil rule, directly above it, which by implication, if we're talking implication, and statutory construction, albeit these are rules of the Supreme Court, what we know is that if the Supreme Court intended that to be permissible in a civil proceeding, they would have included it in that section above as it relates to civil proceedings. They did not. They only addressed this particular issue in a criminal proceeding.
All right, thank you very much. All right, court overrules the plaintiff's objection. Dr. Higgins will be permitted to testify.
Your Honor, just out of an abundance of caution, would we be able to meet with Dr. Hagen before he testifies, just to make sure we don't run afoul of
Yeah, are you agreeable to her just instructing him, what he can and cannot based on my ruling?
Yes.
All right, that's fine. So we'll take a short break, and he'll be your first witness.
Yes, we'll read the deposition, read the RFAs, and then call Dr. Hagen.
All right, are there any other experts being called today?
We do. We have Dr. Klinger.
Okay.
I thought we had worked that issue out, given the agreement related to Dr. Shufflebarger, but I understand today that there's objection, so.
All right, then we'll be in a short recess, and as soon as we're ready to start the defense's case, okay? All right, thank you very much. Brief recess.
Please stand for the juror. Nine jurors in the box, you may be seated.
All right, plaintiff, you request a poll?
No, Your Honor.
All right, defense request a poll? All right. Good morning, ladies and gentlemen. Thank you all for coming back. Not that I gave you a choice, but I appreciate it. I hope everyone had a nice weekend. We are going to proceed with the defense case at this time, and you may call your first witness.
Your Honor, we're going to begin by playing portions of Ms. Werner's deposition.
All right.
Before the shooting on January 6, 2023, did Dr. Parker ever explicitly tell you that she would promise to agree, or promise or agree to protect you from John Doe?
No.
And this would include protecting you from a potential shooting or any other assaultive conduct by John Doe?
Did she tell me those words? Is
Yes,
that
did
what
she,
you're asking?
before the shooting, did she ever explicitly promise or agree to protect you from an assault by John Doe?
No.
On January 6, 2023, was the only time you communicated with Dr. Parker directly before the shooting was when you went to her office at lunch to tell her about the behavior in the lunchroom?
Yes.
After that conversation, did you have any further communication with Dr. Parker?
No.
Do you have any direct knowledge, personal knowledge, of how Dr. Parker responded to any report regarding whether John Doe had a weapon?
Yes, what Mr. Rawls told me when Mr. Rawls came and spoke in my room.
I'm asking for personal knowledge that you yourself overheard from Dr. Parker.
Herself speaking?
Yes.
No.
At the time you spoke with Dr. Parker in her office on the morning of January 6th when you left the lunchroom, did you have any knowledge that John Doe might have a weapon of any kind?
No.
Did you have any reason to suspect he might have a weapon of any kind?
No.
But you received warnings after you spoke with Dr. Parker about John Doe potentially having a weapon.
Yes.
And then you received subsequent information throughout the day about John Doe, or you either observed or heard things that made you concerned that he might have a weapon.
A little bit, yes.
You never told Dr. Parker that you had reason to suspect that John Doe had a weapon, correct?
I only spoke to her at the lunchtime.
And you didn't convey the new information that you gained throughout the day to Dr. Parker.
I only spoke to her at lunchtime.
Correct. Did you ever isolate John Doe from the class on January 6, 2023?
No.
And you never sought out guidance, Ms. Palladini or Mr. Rawls on January 6, 2023?
No.
All right, and for the record, ladies and gentlemen, that video and the transcript are Court Exhibit E.
Your Honor, I would next like to read the 4 requests for admissions.
All right. Ladies and gentlemen of the jury, before cases come to court and are actually presented before you, there's something called discovery that happens where the parties exchange information. Defense counsel is going to read to you from some of that information in the form of what was a request for admissions. This is going to be admitted, the parts that she will read as Court Exhibit D.
Defense request for admission 4 to Ms. Werner. Admit that on January 6, 2023, before the shooting occurred, you did not receive any communication from the defendant expressly promising or agreeing to protect you from any risk of harm by John Doe. Response admitted. Request for admission number 11. Admit that before the shooting on January 6, 2023, you did not communicate to defendant there was a reason to believe that John Doe might possess a firearm. Response admitted. Request for admission number 12. Admit that on January 6, 2023, the only time you communicated directly with the defendant before the shooting was when you went to defendant's office and told her about John Doe's behavior during lunch. Response admitted. Number 18. Admit that on January 6, 2023, before the shooting occurred. You did not receive any communication directly from the defendant acknowledging that she knew that John Doe might possess a firearm. Response admitted.
All right, and the court will provide you as Court Exhibit D a redacted version of that with the 4 answers. So we'll need to redact that. Okay. All right, next piece of evidence or witness.
Witness Dr. Lee Hagan.
Counselors, I think she's up.
Do you swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, once again?
I do.
Follow me.
You may proceed.
Can you please state your full name and spell your last name for the record?
Lee D. Hagan, Ph.D., and the last name is Hagan.
And what is your professional address?
I'm in Chesterfield, which is near Richmond.
And what is your profession?
I practice clinical and forensic psychology.
When were you first licensed?
In 1982.
In what state?
That was in Georgia.
Are you licensed in Virginia as a clinical psychologist?
I am, and I have been since 1982.
Can you please tell the jury about the type of practice that you have?
I consult with attorneys and testify, as I will today.
In the areas of forensic psychology?
Yes, where mental health issues are concerned.
And Dr. Hagan, can you tell the jury what is forensic psychology?
It is that intersection of issues of human behavior and legal questions.
Dr. Hagan, will you please tell the jury a little bit about your educational background?
Mm-hmm. Yes, thank you. I have an undergraduate degree in psychology from University of Virginia, and then I earned a master's degree in counseling from UVA. Thereafter, I went to the University of Missouri in Columbia, Missouri, where I earned a doctorate in psychology.
Do you have any postdoctoral training?
After earning my doctorate degree, that's the PhD, I have hundreds of hours of continuing education, almost all in the field of forensic psychology.
Dr. Hagan, do you have any advanced certification?
I do. It is my privilege to be a diplomate of the American Academy of Forensic Psychologists. A diplomate is someone who's been granted a diploma, thus diplomate.
And describe for the jury what the board certification process entails.
When I went through the process in the 90s, there were 3 hurdles I had to clear. First, I had to show sufficient evidence that my practice was indeed forensic in nature and that I wasn't a psychologist who just occasionally showed up in court. I cleared that hurdle. And the second hurdle, I had to write up 2 reports or case analysis from different areas of law, and that was submitted to a committee to see if my work was up to snuff and met their standards. I cleared that on the first pass. And then finally, I flew across country for an oral examination by a panel of other psychologists who were already board certified. I cleared that on the first pass.
And you mentioned that you are a forensic diplomate. How many forensic diplomates are approximately in the Commonwealth of Virginia?
Well, of those who are in full-time private practice, last check there were only 11.
Are you a member of any major professional organizations?
I am.
Can you please tell the jury about those?
The American Academy of Forensic Psychology, the American Board of Professional Psychology, the Psychology and Law Society, and the Association of Family and Conciliation Courts.
Have you provided training for students?
Many times. For about 10 years, I presented each semester to the third-year law students at University of Richmond Law School. I was the director of psychology training for the doctoral internship program at McGuire VA Hospital in Richmond. It's been my privilege over the years to have individual tutorials, intensive independent study students from Virginia Union University, Virginia Commonwealth University, University of Richmond, University of Miami, Vanderbilt University, and William and Mary.
Do you provide continuing education for other professionals?
I certainly do. I've given many continuing education presentations to mental health professionals and others.
Do you provide consultation and supervision for other professionals in their forensic work?
Not supervision, but lots of consultation. In fact, just yesterday I was assisting another psychologist who had a thorny issue involving her court testimony. This Friday,
Hearsay.
It can't. Anyway,
We'll
you wanna
move
object?
on.
Okay, sustain.
Okay. Dr. Hagan, how many psychological assessments have you conducted?
at least 1,000.
And other than for private legal firms like mine, who else have you conducted evaluations for?
For the court-appointed attorneys, for prosecutors in a variety of states, for the Virginia Attorney General and others.
And how many times have you qualified as an expert in court?
477,
And is that in state court as well as federal court?
state and federal court.
Is that only in Virginia, Dr. Hagan, or other states?
No, I have qualified as an expert in clinical and forensic psychology in Virginia, North Carolina, Maryland, Delaware, Pennsylvania, West Virginia, Ohio, and if I didn't say it already, Florida and Texas.
I'd like to, at this time, move to qualify Dr. Hagan as an expert in forensic and clinical psychology.
Any objection or request for voir dire?
No, Your Honor, I note the objection.
Continuing objection for it.
Yes, Your Honor.
All right, he is so qualified.
Dr. Hagan, who hired you?
You do.
And what were you hired to do?
To review records and develop opinions relevant to this situation.
And what specific issues were you asked to address when mental health professionals are in a forensic capacity offering opinions on a mental health diagnosis in court?
One, whether the standards for forensic mental health apply for a person conducting an assessment in a situation like this, and also to offer opinions on the methods and procedures that a mental health professional should use when conducting an evaluation and rendering a diagnosis, with full anticipation that that information will be used in court. And then finally, the third of 3 points, to offer information about the problems when offering a mental health diagnosis in court.
And Have you ever met the plaintiff, Ms. Werner?
I have not.
What about Dr. Parker, our client?
No.
And I want to ask you to tell the jury about the information that you considered. Mr. Coleman, could you just publish that to Dr. Hagan only?
So there were 4 categories of information that I considered. The first was information from the plaintiff that she provided to the defense side that included her complaint and some other information. The second category I considered were the plaintiff's medical records, including her out-of-work notice from...
Object, Your Honor. I don't know if the witness isn't offering any opinions pertinent to the plaintiff. 703 does not permit the witness to opine or to begin to testify as to all the information that they relied upon.
I'm sorry, he's just testifying to what he reviewed, and you're objecting to that?
Correct.
Okay,
In other words, he's just saying these are all the things I looked at.
that's overruled, it's relevant.
Okay. So the plaintiff's out-of-work note from February 14 of 24, and then there were some counseling records from a group called Abundant Life, both before and after January 6 of 23. And there was the Boulders Ambulatory Surgery Center, the North American Partners in Anesthesia, the Ortho Virginia records, the Riverside Orthopedic and Sports Medicine records, the Riverside Physical Therapy records, the Riverside Regional Medical Center X-ray records, the primary care physician records out of West Point Family Medicine, and the plaintiff's radiographs, as well as the Newport News Fire Department's patient care report from January 6 of 23. So that's the information provided by the plaintiff, followed by the medical records I reviewed. Then there were 2 other categories, the third being plaintiff's 2-part deposition, and I'm not sure if I can...
I think you can say what he reviewed, Your Honor.
Okay, as well as the plaintiff's mental health expert report and designation, Dr. Watson. And then there was the 4th category were other materials that I considered, and those included the following. Of course, Dr. Watson's report, and then Dr. Watson's deposition, the plaintiff's Empire Beauty School records, her grades, the requirements, her attendance, her performance, as well as the plaintiff's emails and her text messages before and after January 6th of 23, her Facebook posting, text messages between the plaintiff and her colleagues, and text with friends and other colleagues. And there's an agency in Virginia that licenses professionals to do certain things like hair, nails, and so forth. That's called the Virginia Department of Professional Occupation Regulations, to verify the plaintiff's license, and also to see what their requirements are for a person to become licensed as a hair person.
Dr. Hagan, is the information you considered of a type usually relied on for the purpose for which you were hired?
It is.
And are there any issues about which you will not be offering opinions?
Several. I'm giving no opinions whatsoever on liability. I'm giving no opinions about anyone that I haven't personally evaluated. and I'm not going to get out of my lane and reach into the job of the jury with any ultimate opinions.
As a result of the information you considered, did you form opinions?
I did.
And are the opinions you formed held to a reasonable degree of psychological certainty?
They are.
Dr. Hagan, when assessing whether the forensic practice standards apply, what standards apply to a mental health professional when offering a diagnostic opinion in court? Tell us about the forensic standards that apply both to a psychologist and a psychiatrist.
One of the sources of standards comes from the American Academy of Psychiatry and Law. And that standard says that a mental health professional's...
Objection, hearsay.
You have a response?
He can state the basis for his opinion, Your Honor. That's clear in the case law. Otherwise, inadmissible hearsay forming the base of an expert opinion may be admissible for a purpose other than the truth, such as to demonstrate the basis of his opinion.
Are you personally familiar with the forensic standards?
I am, Your Honor.
Overruled.
So that standard from the American Academy of Psychiatry and Law says that a mental health professional's objectivity is enhanced when the professional considers all of the sources of information available when forming an opinion to be offered in court. That's one. Also, with which I am very well familiar, the American Psychological Association's Ethical Principles and Code of Conduct, 9.01, says that when offering an opinion, if the evaluator is aware of certain information that he or she didn't develop or wasn't available but could be relevant and helpful, then they have a responsibility to tell their audience in their report or through their testimony what information wasn't available and how the absence of that information could negatively impact the conclusions they ultimately drew.
And Dr. Haken, as a result of everything you reviewed, what opinion did you reach about whether the forensic assessment standards were applicable to a mental health professional's assessment?
I offer the following opinion to a reasonable degree of psychological certainty. Those standards which I just cited are applicable when a mental health professional offers opinions having assessed a person for the purpose of litigation, that is, for going to court.
And what is the responsibility of a mental health professional when offering an assessment of a person in court for litigation purposes?
To explore all of the sources of information that could be relevant and helpful, and to identify those sources that could have been useful but weren't available or weren't available at the time, and to state what impact the absence of that information could have on their ultimate opinion.
And does that relate to issues about the amount of the source of information that the mental health professional has?
It does.
Okay. And what about reliance on self-report versus other information?
Well, self-report means when the person who's being evaluated comes in and tells the evaluator things, information. A good starting point. But it's not the end point. It's important for an evaluator to consider all of the information, including information that may not line up exactly with what the person said. Just like in court, under direct exam, you're not just going to hear my answers to these questions. there'll be cross-exam so the jury can figure out what weight to give what I have to say. That's analogous to when an assessment is done. You would ask the person, how are you doing? How are you feeling? What's going on? What seems to be the problem? But when it's done with reasonable foreknowledge, that is, you know in advance that this is going to be used to assist a judge or jury in determining a legal fact, then there is a responsibility to develop collateral informants and to review records so that you have the full movie of the person's life rather than a snapshot at a moment in time.
Does the mental health professional rely on any psychological testing?
Objection, Your Honor. It's outside the designation. I don't know what we're talking about.
All right. What is, do you have a response?
I'm sure it's in his designation. Do you want me to? Your Honor, the report is 23 pages. I will not spend the time going through it now. I'll move on to something else. There's plenty of other things we can talk about.
That's sustained. Go ahead.
Okay. Does the mental health professional consider the person's adjustment prior to the index event for which they have been engaged?
Yes, the mental health professional doesn't cherry pick the information.
Object. The question isn't, does this person do this or that? This person's been proffered to testify as to what a mental professional ought to do or should do. And the framing of the question is, do they do this? Do they do that? Do they do this? Isn't appropriately frame the issue within the context of what he's been proffered to testify to.
All right, you have a response?
I can rephrase the question. Should a mental health professional consider records and information prior to the index event?
Yes.
And where would one gain that type of information?
Well, from what the person tells them and what they read from other sources. They need to have an appreciation of the context of why are they even getting this referral? What's the question to the evaluator?
Does the mental health, or would a mental health professional consider functioning prior based on collateral interviews and such?
Absolutely.
And Dr. Hagan, what is the mental health professional's responsibility if they don't do all of the things that you just said?
They have a responsibility to their audience to say, here's some things that I didn't develop. Here's some things that I sought, but they weren't available to me when I formed my opinion. And here's how the absence of that information could impact the opinion that I developed.
Do you hold all of your opinions to a reasonable degree of psychological certainty?
I do.
Go ahead. Thank you, Dr. Hagan.
My turn?
Yes.
Okay.
Object. This is a,
Is roadmap?
yes, we're not doing a roadmap.
I'm gonna road up every witness.
You can do a roadmap with your witnesses, but not with mine.
All right, I'm going to sustain the objection. Don't need to give him a roadmap.
Dr. Hagan, you ever heard of the phrase armchair expert?
Yes.
Okay. And you testified earlier that a job of a forensic psychologist is to, I think it was, assess the intersection of human behavior with legal questions. Is that right?
That's the definition of forensic psychology.
So that's a yes? That's
It's not a yes. I'm clarifying that that is the definition of forensic psychology. It doesn't dictate what a forensic mental health professional does in each case. It needs to be driven, the conduct in each case needs to be driven by the standards that apply and the facts specific to the case.
And that's your opinion because you, in fact, didn't address the intersection of human behavior and legal questions in this case because you didn't evaluate Ms. Werner. True?
False.
You evaluated Ms. Werner?
No.
That's all I need to know. You did not evaluate Ms. Werner, correct?
I have not.
And so when you said you performed 1,000 psychological assessments, all 1,000 of those are people who are not in this courtroom. True?
That's true.
And you said that you testified, hundreds and hundreds of times. You testify almost every week.
No.
You testify a lot.
477 times.
Did you testify last week?
Not last week.
Soon, recently.
In October.
Okay. And when you were asked what you would be opining on, you agreed that you wouldn't be offering an opinion on liability, correct?
True.
And in your experience in forensic psychology, that's a, quote, legal question, correct?
Well, it's outside of my area of expertise, the liability question is. So I'm going to stay in my lane.
All right, let's stay in the lane then. And that lane in other circumstances included actually providing an evaluation of somebody at issue, true?
I have done that, yes.
And you understand that the court can order that you provide an evaluation of somebody if it's requested?
The court can order it, yes.
And that defense counsel, if they wished, could ask you to perform an evaluation, true?
Objection, Your Honor. First, it's leading. It's not relevant. That's not an issue before the court.
All right, well, it's cross-examination. I'll allow him to lead, but what about relevance? You have a response to that?
Yes, Your Honor. The assessment is he's been offered to testify as to what a forensic psychology is helpful to do. And in this case, we're trying to figure out what he did, what he didn't do, so that the jury can understand how best to use or to evaluate his opinions.
Your Honor, Dr. Hagan has no input on defense counsel's decisions with respect to whether there would be an evaluation. He was very clear that he said he did not personally evaluate her and didn't need to offer his opinions.
Can you ask your question again, Mr.
Sure.
Young?
Were you asked to evaluate Ms. Werner?
No.
Overrule the objection. Go ahead.
Did you ask to evaluate Ms. Werner?
No.
You understood that a question that this jury would be asked to decide is damages, correct?
Yes.
You understood that a question that this jury would be asked to decide is causation, correct?
Yes.
And you explicitly within your report stated, give me a moment here. That you will give no opinions about persons whom you have not evaluated, true?
True.
So you're not opining as to any, you did not offer any opinions as to her mental health diagnoses, true? You did not offer it in your report, true?
I'm not giving any opinions about her diagnosis. I have opinions about how the diagnosis was reached, the methods and procedures, giving no opinions about the plaintiff herself.
So to answer my question, the answer is yes, correct?
The answer is the one that I just gave.
Okay. And so when we're addressing this specific issue in this case regarding post-traumatic stress disorder, you did not render any opinions regarding post-traumatic stress disorder, correct?
I rendered opinions about how that assessment was done. I'm not giving any opinions on the truth or the validity of the opinions.
That's because you didn't want to get your hands dirty and
It's
actually
because I'm
address it.
staying within my lane and not offering any opinions about anyone that I didn't evaluate myself.
Because that would violate its own ethical rule, true?
I think that is true.
There's a Goldwater rule that says you shouldn't be offering opinions about people who you haven't assessed personally, true?
I'm not familiar with it under the Goldwater, but I know under the American Psychological Association's Ethical Principles and Code of Conduct, published in 2016, section 9.01 through 9.03, it says you shouldn't do that, and I'm not doing it.
Thank you. No further questions.
Any redirect based on that cross?
Just a little follow-up. You were asked about whether you needed to evaluate Ms. Werner to offer your opinions today,
I was asked that.
and you addressed that when you spoke to the jury the first time and said you did not need to do that.
First time, and second time, and third time. Yes, ma'am.
Thank you, Dr. Hagan.
May he be excused?
Yes.
All right. You are excused from your subpoena. Please don't discuss this case. All right. Thank you. You may leave the courtroom. All right. Next witness.
Next witness, Dr. Klinger, but I think there are some issues that Mr. Kniaz wants to address.
All right. All right. Before we have more testimony, we are going to allow the jury to take a quick break, and we will address some legal matters.
Please stand be here.
All right, so I have the expert designation from the defense, and I have, starting with Ms. Klinger's designation, starts on page 17. Is that what we're working off of? Yes. All right, very well. All right, I had withheld a finding after our pretrial motions day on this, and have you tried to consult and solve any issues?
The defense counsel has sent us what they intend to proffer, and I think that, and I've showed them some highlights that I have that I object to this morning. So I don't know what you'd prefer, whether you'd like them to proffer and then we object, or vice versa.
I guess I would probably prefer them to proffer at this point, to sort of narrow those things, and then I'll allow you to respond.
Yes, Your Honor.
Your Honor, my understanding is it doesn't have an objection to everything. I think for us to proffer things that are not objected to, it might be best to just address the specific.
Okay.
And I have a marked up version of what I sent last night, if that would help, Your Honor, rather than having to read off the.
Any objection to me taking a look at that?
No, Your Honor.
All right. All right, the court accepts as defendant's proffer pages 17 through 28 of the expert designation and opinions expected to testify to, with the line throughs being done by the defense. All right, Mr. Benioff. I guess for the record, it would be Court Exhibit F.
Just so we're interpreting, my understanding is that they've struck through the things they're not providing.
That's my understanding. yes.
Okay. So first,
Just one point of clarification, Your Honor. On the issue of gross negligence, there was an agreement with Dr. Shuffleberger not to use the word gross negligence, and in the email that I sent last night, it spoke about what Mr. Benioff refers to as the buzzwords, which are in the jury instructions that have been offered to the court, such as indifference, lack of any care, that sort of thing. So I just want to make sure that when the word gross negligence is written, that Your Honor understands that she would be speaking to that, but just in more phrases that are in the jury instructions and some of the case law.
all right, so if we can start on page 18, Judge, there's a line that suggests, and this is the second paragraph, it's the third or fourth sentence down, that says that Dr. Klinger is expected to testify that Dr. Parker did not show indifference to plaintiff as constitutes utter disregard, caution amounting to a complete neglect of safety of the plaintiff with respect to her involvement in the education of John Doe, including but not limited to January 6th. The issue there is that it seems to suggest that there's going to be testimony proffered that does not relate to January 6th, that actually is regarding to sort of educational duties generally before January 6th, which I think is impermissible and not an issue for the court, for the jury to decide in this case. And I figured I'd go one by one.
Right, so, I mean, I guess we need to clarify that then.
Your Honor, I think I can short circuit this. She's not offering any opinions beyond January 6th. That was just an omission on my part when I was marking out.
Okay.
Yeah, I think I caught it in some places, but not every one.
All right, so if we limit that to on January the 6th, no objection, correct?
Yes, yes, no objection, with the exception that there seems to be later discussion of how she has educational duties, and whether she met those educational duties, I think, is an issue.
Okay. Well, we'll strike, just once again for the record purposes, I'm going to use X's since you lined things out. I'm going to use X's on this exhibit.
Thank you, Your Honor. That's a
All
good
right.
idea.
Okay, so that just is limited to on January the 6th. All right, next, Mr. Benioff.
All right, if we go to the bottom of page 20, Judge.
I'm also initialing those X's. All right,
Thank you, Your Honor.
for the record. All right, go ahead.
Bottom of page 20, there's a very last sentence says, Dr. Klinger is expected to explain to the jury that an assistant principal is not a law enforcement officer, does not receive law enforcement training, generally receives little education and training from a school board regarding how to respond to potential threats in the elementary school setting. There's a couple issues with this, Judge. First, I think it is well within the province of the jury that an assistant principal is not a law enforcement officer. And so in that context, it's not helpful to any issue at fact. And then furthermore, this generalization as to what is trained or what information is provided to an assistant principal without being specifically focused to the case here, in other words, Newport News or even Dr. Parker, invites the jury to speculate as to whether that's true for Dr. Parker or whether Dr. Klinger is just saying, this is generally true for everybody, but who knows how it applies in this circumstance.
Excuse me, counsel, can you identify which page you're referencing?
Sure, it's bottom of page 20, top of page 21.
Thank you.
All right. Any response to that?
Just a moment, Judge. Judge, I'd respond with respect to testimony that stating that Dr. Parker is not a law enforcement officer and receives limited training. I would agree that to the extent that she would testify that to the obvious that Dr. Parker is not a trained law enforcement officer, that is common knowledge. The jury can draw that inference from their own evidence and through their own independent assessment of what they hear. But I do think that it is the proper purview of Dr. Klinger to shed light on and explain to the jury that there's often an intersection between the roles that are typically thought of for law enforcement in terms of searching students for contraband, ensuring safety, can overlap with the obligations of an administrator. And Dr. Klinger can explain to the jury that just because administrators and school teachers and staff often have to fulfill these roles and undertake certain responsibilities to conduct these types of searches, that does not mean that they are necessarily trained to the same degree that we would expect of law enforcement officers.
All right, I'm going to grant it as to is not a law enforcement officer. I'm going to deny it as to the rest with leave to cross-examine on those issues as it particularly applies to this case.
Yes, Your Honor. All right, ready for the next one?
Yes, sir.
Last paragraph, page 21, big paragraph. It's all about Dr. Klinger talking about mental health crises in children generally and attempting to, I think, equate that to circumstances here. I mean, we just heard from a forensic psychologist that says we can't offer opinions ethically as it relates to people we have not evaluated, and this seems to do it carte blanche, and she's not an expert in the field of psychology or psychiatry, nor is she an expert in the field of determining what is a pandemic in the context of mental health crises in America. And ultimately, it's not a helpful issue to the jury or the trier of fact in this circumstance.
All right.
Your Honor, we'll strike the whole paragraph. She's not going to be testifying as to that. It begins on page 21. Dr. Klinger is expected to explain and ends with overturning desks.
Court is in agreement. All right.
Next paragraph, page 22, we also object to, Your Honor. This is that Dr. Klinger is expected to testify or educate the jury upon weapon or gun talk or mimicking in an elementary school setting. Again, this is, essentially attempting to proffer inadmissible hearsay to say that to normalize this behavior, even though there's no basis for that opinion in the context of this case, or to be helpful in this circumstance. We don't know that any of the people here had any circumstance or observation of this gun talk or weapon talk or mimicking, and that this would sort of insert an issue in front of the jury about this generalization that is inapplicable.
Why would an expert be allowed to testify to this?
Judge, first, I think that she can testify based on her training and experience that these phenomena, including children who commonly mimic guns, commonly mimic weapons, is a frequent occurrence in schools. She can testify based on her training and experience in decades in serving as both a teacher, an administrator, an authority figure in these school settings, that this is something that is routine, and that is something that is not common knowledge to the jury, that would assist them in deciding material facts at issue in this case, including whether or not Dr. Parker's response to the reports she received were reasonable in light of the information that she received. We've heard evidence in this case that a number of the reporting parties who interacted with Dr. Parker subjectively believed that the object that JT might have possessed was, in fact, a fake or toy weapon. There's also been testimony from Alonzo Rawls that it's also very common for part of why he thought that there was not a credible threat or credible report at the time he spoke to Dr. Parker was that in his experience in dealing with children, they often confuse weapons with legitimate or innocuous innocent items, such as pencils, erasers, other objects. So this is something that Dr. Klinger can add her experience on. It would not be cumulative. It would be corroborative. In addition, it's something that will come from, will be necessary to provide context for the rest of her opinions. It dovetails nicely into the balance of her testimony, Judge. So for all those reasons, I ask that it not be excluded.
I'm going to sustain the objection. That is something that is can be commonly observed and taken as an experience. All right, objection noted. All right, next.
Your Honor, the next is the beginning part of the very next paragraph, where it starts with Dr. Klinger is expected to testify, and then it goes on to essentially state that Dr. Klinger is going to offer an opinion that what has been reported in the media or the press is inconsistent with her review or the factual circumstances of this case as she's found them totally impermissible. We've told the jury that they can't decide this case on what's out in the press, and to invite a witness to now talk about what they saw or heard in the media compared to what they've seen or heard in deposition transcripts, which, as Mr. Hagan's argument illustrates, what happens in depositions isn't always what happens in this courtroom, because Mr. Rawls never testified to those things, nor has Amy Kovac, despite their attempts to put in a video, testified to the thing that he said. And so for an expert witness to say, what I saw out there is not consistent with what I've seen in these papers, helps the jury nada.
You have a
Respond
response?
briefly. I would only say that to the extent that opposing counsel may open the door to the subject, it would be proper. But I would agree with counsel that this is something that should be elicited on direct, just injecting issues in the public domain into the court of law here. However, I ask that we have leave and reserve the right to explore those issues if they open the door to it.
All right, so you agree that Mr. Hogan, you agree that they have not opened the door at this point with Shufflebarger's testimony, but may on cross-examination with your witness, is that correct?
That's correct, Judge.
All right, do you have any problem with that?
No, Judge.
Okay. All right, let me make a note on this. So the objection is granted to the extent that the door is not opened.
We don't think the entirety of page 23 ought to come in, Judge. We can take it one by one.
And so we're skipping the rest of that paragraph on 22. You're fine with, we're now going to page 23?
Yes, Judge.
All right.
So page 23, when we look at the second paragraph, Dr. Klinger is expected to testify, and this is, again, involvement in education prior to January 6, 2023, as I articulated before, I think is irrelevant to the issues at bar. And then it talks about how public schools must follow federal and state laws which require that all children, even those with disabilities and those prone to disciplinary problems, including violence, receive a free, appropriate public education. Again, that's not an issue to be decided in this case, nor is it relevant or pertinent to an issue to be decided in this case.
Any response?
Your Honor, I think we can short-circuit this as well. Given the narrowing of the case by the plaintiff, we can omit probably all three of those paragraphs on 23.
Okay. Without objection, court agrees. All right.
That brings us to, at least in my view, the last paragraph on page 24, which is next. This is, and I understand from opposing counsel that there isn't going to be an attempt to parrot or to demonstrate any inadmissible hearsay or hearsay statements, but just to assert it for the record, essentially this paragraph attempts to do today, what they attempted to do yesterday, as it relates to video body camera footage.
All right, so it's all hearsay.
All hearsay.
From what I see. All right, any response?
Yes, Your Honor. I anticipate that we'll revisit these arguments later today, and so we can rule on them at the appropriate time. But I would just say that I would identify that none of these statements will be offered for the truth of the matter asserted. They are non-hearsay. They're also relevant and germane to this case, as will be established at this subsequent point in this hearing when we address those evidentiary issues.
All right, but not through this witness. You agree with that?
What I would say, Judge, on this point is that Dr. Parker, under Carteret versus Commonwealth, as well as the Castillo case, a whole line of cases establishing that an expert may testify even on direct examination to an inadmissible, otherwise inadmissible hearsay testimony, provided it is offered for the limited purpose of explaining the basis of their opinion. That can be cured. Any risk of the jury not understanding that can be addressed with a proper limiting instruction.
All right, I'm going to sustain the objection. I'm also going to find that it's more prejudicial than probative. All right.
That gets us to page 25, the second to last paragraph. There's a sentence that begins with, rather, Mr. Rawls testified in his deposition. And again, it's in the event that they ask her to parrot deposition testimony, it's impermissible. And I can further illustrate the argument, but it's 702, 703.
Okay, so that's that whole sentence.
Correct, all the way until the end of the
paragraph. Correct. All right, any response?
Judge, I stand on my prior arguments. This is the same issue. They can elicit this even on direct examination, otherwise inadmissible hearsay testimony, provided that is offered for a limited purpose, namely to establish and explain the basis for the expert's opinion. I would note as well, Judge, with respect to the prior issue, some of this may be necessary or relevant to the subsequent evidentiary rulings as to the admissibility of video statements from Ms. Kovac that will be addressed later in these proceedings. I'd ask the court, to the extent the court sustains any objection at this stage, that we have leave to revisit these arguments at the appropriate time.
So I think they can have her testify to what she relied on, but I agree that he cannot parrot this is what Mr. Rawls said during the deposition. So I think it needs to be couched in the language by your expert that she relied on information provided in depositions, and from her understanding, the following things occurred. But is there an objection to that?
There is, Judge.
Okay.
And the reason is that while I agree the expert may draw conclusions upon otherwise inadmissible testimony, that's 703, the inquiry into those otherwise admissible testimony may only be done on cross-examination and cannot be proffered in direct. And so if I agree that they said, and in your review of these facts and information, did you review the deposition of Mr. Rawls? Yes. And did you rely upon the testimony of Mr. Rawls in forming your opinions? Yes. And what are those opinions? Here are my opinions. I agree that that's permissible, but the question of, and was there a determination that Mr. Rawls made that you found reliable that you then relied upon in your testimony? Yes, his belief was X. Is whether it parrots the statement or not, you're getting into facts and circumstances that are inadmissible through this medium. You know, Mr. Rawls testified to what he found and what he didn't find. And it may be an inquiry that's permissible in cross-examination, and that's addressed in 705, where it says in civil cases, an expert may testify in terms of opinion or inference and give reasons therefore without prior disclosure of the underlying facts unless the court requires otherwise. The expert may, in any event, be required to disclose the underlying facts or data on cross-examination. So that's what we're talking about here, that distinction between the two.
Judge, may I respond briefly?
Hold on, let me read the statements, then I will let you.
Thank you.
All right, so really there are two conclusions in this paragraph they're attempting to solicit.
I agree.
Okay. First one being, at the time of the shooting, it had not been determined that there was a credible threat. Right? That's the first.
Correct.
And then it says, and. Then the second conclusion, or facts, that until the shooting occurred and he went into Ms. Werner's room where he determined that John Doe was the shooter, he did not believe that anyone at the school was at risk of harm by John Doe that day. So basically, Ms. Hogan, you're asking her to testify to conclusions, or her drawing conclusions, that based on his statements. Is that correct?
No, what I would say, Judge, is she would be offering this testimony to explain the basis of her expert opinion. And part of that that's expressly contemplated under 8.01-401.1, which controls the admissibility of this type of evidence. That's been interpreted by the Court of Appeals in Castillo versus Loudoun County. That's 68 VA App 547. It's a 2018 case. Drawing on a huge line of authority, the court said unequivocally, it acknowledges there's a dichotomy between what's allowed on cross and on direct with experts in civil cases. Independent of that, regardless of that, additionally, quote, the otherwise inadmissible statements forming the basis of an expert opinion may be admissible for a purpose other than their truth, such as to demonstrate the basis of the expert's opinion. They cite Cartera versus Commonwealth, settled precedent that is 19 VA 516 from 1978, and that was a case where it wasn't just a vague description of hearsay statements made by third parties who were not present in the courtroom. There were explicit statements regarding the patient's symptoms and diagnoses that were admitted into evidence. And those were things that they were the statements themselves. The difference is that an expert can talk about those things provided that the jury is instructed this is to be considered solely to understand the basis of her opinion. So I would contend, Judge, regardless of whether we're referencing verbatim discrete statements or just characterizing them in a general form, this is admissible. It is contemplated under the law, provided that it is clear to the jury that this is not to be considered for its truth, which is not even offered for that purpose. Regardless, Judge, I would also say that looking at the statements themselves, I'm not asking Dr. Klinger to talk about or say that she made a determination based off of Mr. Rawls' conduct or his investigation. I just need her, the goal here is to have her testify that these were statements that she relied upon that will illustrate whether or not proper protocols by the administrator were followed in this case. Those are the material issues before the jury. And so all this can be cured with a limiting instruction. It is expressly contemplated under the law. If you look at Castillo, they cite at least 2 other cases supporting this well-established principle.
Any last word?
Yeah, Castillo's a criminal case, and 703, which is the same as 801, 401.1, which Mr. Hogan cited to, explicitly differentiates civil cases from criminal cases. And what we're risking here is the precise thing that they're saying they don't want to that they're not going to do is exactly what they're offering it for. You can't in one sentence say, we're not offering it for the truth of the matter asserted, but then we want to show it to show the reliability or the basis for the opinion testimony of the expert. If it's not for the truth, then why did the expert rely upon it factually if it's not true? And so to say we're not offering it for the truth, but we're showing it to show what she based her opinions on is talking out of both sides of your mouth.
I find that that's more prejudicial than probative. It also calls for speculation. So you're allowed to ask her, did she review and read the deposition, and based on the statements by Mr. Rawls in that, did she come to conclusions? I'm not going to let her testify to what she believed Rawls' conclusions were. I think it's more prejudicial than probative and calls for speculation.
I understand, Judge. I respect the court's ruling. One thing to flag for the court, my understanding from the court's prior deferred ruling or ruling with respect to video evidence coming from Corporal Blythe, which contained Ms. Kovac's statements, I believe, and I took the court's comments for the bench to articulate that that evidence may be conditionally relevant. There's evidence that comes in our case in chief that establishes the requisite nexus to let this come in and make it relevant. Then you would reconsider those issues. This may be the opportunity here. Dr. Klinger, if she's testifying as to how the reporting parties and intermediaries that interacted with Dr. Parker, what they subjectively believed or thought, if she's able to establish that as a factor for an assistant principal to consider, that is what this is oriented towards. It's not designed to elicit inadmissible hearsay or to prejudice their case. It is simply meant to explain, these are the documents that I relied on, this is what they said, here is why they are important. Dr. Klinger will testify that as an administrator in determining whether, when, and how to respond to information, they need to rely and depend on their subordinate staff, the first-line responders. And that includes their subjective assessment of the credibility or reliability of the reports they have first-hand knowledge of. This is all will come from Dr. Klinger, and that will establish the springboard for this additional evidence. So I ask the court to consider that, and to the extent that this court has ruled already on this objection, I ask the court to reconsider it and revisit it when I seek to introduce Ms. Kovacs' statements through the video testimony?
Well, through this witness, it's going to be the same thing. I mean, she can testify what she looked at and what she considered and what conclusions Ms. Klinger, Dr. Klinger, can respond to, or relied on and then formed her opinion based on and what that opinion was, but not the exact statements. I'm not going to let that.
Understood.
They're more prejudicial and probative. So.
Understood.
Just for
Okay.
clarity, Your Honor, Dr. Klinger can testify that the material she reviewed, that it had been concluded that there wasn't a credible threat at that point,
I mean, that's her conclusion. If she's testifying that that's her conclusion, I'm allowing.
without saying it came from Mr. Rawls
Correct.
or that it was a toy gun, but not saying who said it.
Correct.
Okay.
All right. All right, next.
Page 26, Judge. The second paragraph. Sentence that begins with second sentence. Dr. Klinger is expected to explain to the jury that a student in Mrs. Werner's class was interviewed by law enforcement and said the following things. It's pretty much the same thing that we just addressed.
And I'd make the same rule. I understand you have the same arguments. I'd make the same ruling. She can testify to what she relied on, that there were statements, but not testify to those statements.
All right, next page, page 27.
Hold on, let me highlight specifically.
Yes, Judge.
And so really, it's just that in that paragraph, first full paragraph, partial lines of that paragraph, if that paragraph has 1, 2, 3, 4, 5, 6 lines, it's the last two. So basically told interviewers told Miss Werner that John Doe had a gun, and Miss Werner told him to sit down and save it for later.
Right,
Okay.
that second paragraph, the
Correct.
first sentence is fine. This second
Okay.
part of it's out.
All right. Finally,
Last page, almost. Page 27. The paragraph that starts with additionally. And it says, Dr. Klinger is expected to explain to the jury the extremely rare nature of the incident at Rich Neck and that John Doe is amongst the youngest school shooters in U.S. history, expected to discover the relative rarity of school shooters under the age of 10, inability to construct a predictive profile. Your Honor, I think all of this is immaterial and essentially asks her to assess the universe of information that's not even the universe of this case. It's saying, tell us how many other school shooters there are in this country, and that's not an issue to be decided by this jury.
all right. Defense response?
Yes, Judge, to respond, I would note that it is common practice. It's replete in the case law of examples of experts testifying based on their training and experience in the particular domain, that things are either uncommon, rare, occur often, or frequent. That does not run afoul of constituting irrelevant or speculative testimony regarding raw statistical data. It doesn't approach that in any respect. It also isn't something that's pure common knowledge. It is something that someone with the appropriate qualifications, training, and experience has unique knowledge about. They can testify to their experiences. Dr. Klinger is an experienced administrator, teacher. She's done this for decades. She can talk about whether or not this type of incident is rare. That happens in cases all the time. It happens in medical cases where doctors will come in and testify that these symptoms present. They typically manifest in this type of patient presenting with these types of symptoms. It is similar here as well. This isn't beyond the scope of her expertise or credentials either. This is something where she is a trained administrator. She's dealt with kids for decades and decades. She can talk about this and explain to the jury.
All right, I'm going to find that based on her training and experience, once again, assuming that's established, that she can testify to the extremely rare nature of the incident, and that in her experience and knowledge that he's one of the youngest school shooters in U.S. history. However, I do have an issue with starting with the word inability. Actually, so let's just take that next sentence. In this regard, Dr. Klinger is expected to discuss the relative rare schoolships and therefore the inability to construct a predictive profile. I'm not going to allow any of that because there's no evidence that supports why that's relevant in this case. Assuming that's what you were saying, Mr. Beniosen.
Yes, sir.
All right. So I'm going to strike that sentence. And I think the next sentence is cumulative of the first two, unless you want to be heard on that. I mean, I think we're just using the same words over and over again. So I'd say that that language is met by your first sentence.
I think there's a difference between rare and unprecedented, and they're both here.
Well, she can only say it once. If she wants to say it's unprecedented and extremely rare, fine, but I'm not going to let her say it on two different occasions. That understood?
Understood.
Okay. All right, anything else, Mr. Beniosen?
Yes, sir, I apologize. But the next is an issue that was specifically part of the motions in limine, where it says finally, and effectively the witness is now venturing into things post January 6, 2023, and talks about how there is a difference in educational world within training of educators in the world at this stage as it relates to post 2023 incidents, and they can talk about post Rich Neck and these things of that nature. I think ultimately, Your Honor, there's a rule somewhat on point, which is 2407, which is the subsequent remedial measures. Obviously, this is a different situation because they're essentially proffering things that happened after the fact, but they're doing so in order to try and disprove negligence on the part of Dr. Parker by saying that since that time there are more safeguards that are put in place by school boards, there's more training about these things, and the issue there is we're going to be clouding the jury's understanding of, well, what did we know then? I mean, I thought I heard Mr. Hogan in opening statement say, you've got to ask yourself what happened then, not hindsight 2020. And now here we have this paragraph that says, let's talk about the world today.
So that's not specifically spelled out, so I'm assuming that's referenced in the deposition testimony of Robert M. Stewart. Is that where you're pulling that?
Correct. In other words, on the second page,
What page are we on?
we're at the bottom of page 27 going on to page 28. So at the bottom of 27 it says, Dr. Stewart testified regarding post-Rich Neck changes in crisis management, training, security in the schools, clear backpacks, weapon detection systems. In this regard, Dr. Klinger is expected to explain to the jury that in her work lecturing and consulting on school safety, after the Rich Neck case, there has been a dramatic increase in educators expressing concern regarding searching elementary school children. And so the question is, well, why are we going to tell the jury about things post January 6, 2023? I understand if you want to say this is the state of the world on January 6, 2023, and this is what the educational system was like and how training was on and up to January 6, 2023, but clouding the jury's assessment of what happened after the fact. Rule 407 is kind of a shortcut to these.
Which is remedial measures.
Correct.
Okay.
So all of the rules that come after 404 are essentially shortcuts to these determinations of what is unfair prejudice and what is confusing the jury. And by rule, the Supreme Court has said that when we're talking about things subsequent to an incident and it's being offered to demonstrate negligence at the time of the incident, it is inadmissible. It may be relevant to demonstrate other things, such as control, feasibility, things of that nature. And none of those exceptions are applicable here, because what they're offering this to show is not that Dr. Parker could have or did do something differently after January 6, 2023. We know Dr. Parker wasn't at Rich Neck Elementary School for much longer after January 6, 2023. So these are all circumstances and actions taken by people other than her in an effort, in my view, Judge, to argue to the jury, look, had the school system done these things for us.
Which is clearly impermissible under the rule.
Correct.
Right. All right, how is this, that testimony not violative of Rule 2:407?
Judge, simply put, 2407 as well as the statute, it incorporates 8.01-418.1, only prohibit the use of this type of evidence of subsequent remedial measures to prove negligence. It is silent. It does not prohibit or prescribe using that evidence to negate it. Obviously, we're not trying to establish Dr. Parker's negligence. We are negating it. That is not prohibited under this rule. Counsel is correct that this is often shorthand to try to eliminate using evidence for improper purposes. There's public policy reasons behind this. The public policy reason behind the subsequent remedial measures statute is that you don't want to deter a defendant who, after an incident or crisis that endangered folks, from taking measures to improve that, to prevent that from happening in the future. That same policy rationale is not implicated. It is non-existent where the defendant is trying to introduce those measures to negate negligence. The rule is black letter. It is very clear. It only applies to proving negligence, not negating it. Why does that matter in this case? Because evidence of subsequent remedial measures, the fact that at Ridgeneck Elementary School and other elementary schools throughout the country have implemented new safeguards in light of these types of shootings. There's a pre-Ridgeneck and there's a post-Ridgeneck. Pre-Ridgeneck, these were the conditions that existed at the time. Post-Ridgeneck, now we've got all these precautions, metal detectors, clear backpacks, all those things. That doesn't go to shifting blame to some other third party. It doesn't run afoul of the subsequent remedial measure statute, which only prohibits using this to prove negligence. Rather, it goes to the heart of foreseeability. A reasonable jury viewing that evidence can construe that had this truly been a foreseeable incident, had this been on anyone's radar, the staff, the teachers, the school district, that they would have had those precautions in place. That is legitimate evidence.
So what about his argument that it's going to negate negligence as well as basically for impeachment on the foreseeability issue, which is you did not do these things beforehand?
You did not do these things.
Yeah,
these
you
things
didn't have clear backpacks. You didn't have metal detectors, those sorts of things.
Right. And so in your question to me at this time is what about using those things in order to demonstrate foreseeability?
Correct.
The answer is we don't need to know that Ridgeneck did those things after the fact. You can ask the question to the expert. On January 6, 2023, was there a policy at the school that required clear backpacks? No. On January 6, 2023, was there a metal detector at the school? No. You can ask the questions without the prejudicial nature of what somebody did after the fact, which is not a pertinent issue to this case.
Anything else you wanted to say?
No, Your Honor.
Either side have any case law to support their position on this one?
Not at hand, Judge.
No, Judge, I actually addressed this argument expressly in the defense motions in limine or the brief in response to the plaintiff's motion to exclude expert testimony. The authorities I relied on, I did cite some authority. It was largely treatises at this point, emphasizing that this is the purpose of the rule. I also did find one case, Judge, 2022 case. It's Davenport versus Utility Trader Manufacturing Company. That is 74 VA App 181, 2022 case. That is a published decision for the court from the Court of Appeals of Virginia that is binding vertical precedent on this court. And it says that to assess whether Rule 247's general ban on subsequent remedial measures evidence applies, the court looks to two considerations. One, quote, is the evidence offered actually a remedial measure, i.e. a measure that, if taken prior to an event, would have made the event less likely to occur, end quote. And number two, quote, whether the evidence is offered to prove negligence or culpable conduct as a cause of the event, end quote. This is the plain language of the statute. The court applied that plain language. It doesn't prohibit negation.
I don't know if you're familiar with that case. You want an opportunity to respond?
I'm not, Judge.
But I understand the plain language. I agree that that's the plain language of the rule. The issue here is what we're effectively asking the jury to consider is what did somebody do sometime later after the fact of January 26, 2023, and let's then use that evidence to decide an issue on January 6, 2023. And if the question is, were these things in play then? I agree. But you don't need you don't need the risk of prejudice that comes along with the question, this was implemented, or that this became the educational standard, or this is how we train on things. That becomes unhelpful to the jury. If the question is only foreseeability, we don't care what's foreseeable now. We care what was foreseeable January 6, 2023, and the substantive issues of backpack this, training that. You can ask those questions without getting into what life is like post January 6, 2023.
In 1 second. That's all we have.
My other concern, Mr. Hogan, is that regardless of whether or not that information comes in, you then go on to express in the disclosure that because of those factors that we've just talked about, there has been a dramatic increase in educators expressing concern regarding searching elementary school children. I mean, do you say that that's admissible as well, based on those conclusions?
Judge, I think it'd be appropriate to excise that from the opinion.
Okay. That I agree with. All right, so now we're really just down to whether or not she can testify that since the shooting, there have been changes to crisis management, training, and security in the schools, such as clear backpacks, weapons, detection systems, etc. Is that correct?
Yes, sir.
Yes, Judge.
All right.
And that's from Mr. Stewart, a school board employee's deposition, so she's read that deposition.
And that's the basis of it.
Getting back to the Mr. Rawls issue, which is if all she's doing is parroting somebody else's deposition testimony.
But can't she say that she, as part of her expertise, has reviewed that deposition and found that the school did these things? Ms. Benioff, you have a response to that?
I'm reading the transcript so
Sure.
that I can. I think that the second part of your sentence, that the school did these things, is the issue. Because the school is not Dr. Parker necessarily. And so the implication and the purpose of the testimony is essentially to try and say, well, if only they had equipped her with clear backpacks, if only they had equipped her with metal detectors, if only they had done these things for Dr. Parker under that circumstance, then what we're doing in that instance is we're essentially pointing the finger at somebody, and we get into this empty chair issue. We're pointing the finger at somebody after the fact to try and make the job easier or different as it was on January 6th. Again, I go back to, we don't need to get into what anyone has done since January 6, 2023. You can get to the facts of those issues by just asking what was present on January 6, 2023. And if she knows that factually, she can testify to it. If she doesn't know it factually, which seems as though it's based within the record, she may not be able to testify to it factually if it's what Dr. Stewart testified to. She can just say, I reviewed the opinions and this is my conclusion.
Judge, maybe heard, there was a new argument that was raised. I won't belabor the court with argument.
All right.
The new issue that was raised was a pivot by counsel emphasizing and relying on the empty chair doctrine. Let me just emphasize that that is a red herring in this case. We are not offering this evidence to point the finger at someone else for their own liability, that they were at fault, that they should have had these safety measures in place, and therefore, because someone else is at fault, we're off the hook. That's the heart of the empty chair doctrine. It is impermissible. That is not what is happening. It is well established. It is clearly settled in Virginia. There's a distinction between that, on the one hand, pointing the finger at someone saying, because they messed up, I'm off the hook, and pointing to overlapping evidence that is similar in nature to argue that this is unforeseeable as a matter of law.
All right, I'm going to let her testify to those things, exactly how we discussed it, but I'm also going to allow a limiting instruction that parrots that information, cannot be used to prove negligence, pursuant to Rule 2:407.
Or disprove negligence.
Yeah.
Just for clarity, Your Honor, in how Mr. Beniazin suggested the questions get asked, or can she say that she reviewed the deposition?
No, she reviewed the deposition, and those are the things that she found on her review of the evidence, and then we'll give a limiting instruction that that testimony cannot be used to prove or disprove negligence.
Your Honor, she's a national school safety expert. That happened all over the country. It's pre-Rich Neck and post-Rich Neck, just like pre-Virginia Tech and post-Virginia Tech. Standards changed.
Well, then you're just talking yourself out of that testimony, right?
I'm not talking myself out of the testimony. It's the same argument. It's the argument that's in here about the pre and post standards. We just spoke about that.
They just proffered to the court that it would only be offered for the issue of foreseeability of a weapon on campus. And then they've come up to say standards change on how we should judge their conduct. This demonstrates the exact issue when we have these sort of backdoor evidentiary issues, which is we're going to use it for this but not for that. And we start to get into this realm where you have an expert on the stand that says, well, the evaluator ought to do this. And he just doesn't say Dr. Watson. And so we're getting a backdoor attempt to try and address this issue as to standard of care or negligence under the guise of a foreseeability analysis. And I'll point the court to this issue that there's foreseeability discussions throughout her designation that are not objected to. She talks about foreseeability, and we understand that she's going to talk about foreseeability. The question is whether she can say the world as it is today foresees the likelihood of a weapon on campus differently than the world saw it on January 5th, 2023, and that we don't think that that's permissible.
Judge, very briefly, the original argument was that Rule 2407 expressly prohibits this type of evidence. We just had a case, we discussed the case that says that it only operates to prohibit using that type of evidence to prove negligence. It has no operation or legal effect to prohibit using that same evidence to negate it. Us arguing that this is probative of foreseeability is no different. It's in line with what is contemplated by those rules. Foreseeability is the heart of negligence. It's embedded throughout it. That's why it appears in our briefs, it appears in our pleadings, and that's why they don't object to it. This is a false distinction. This is a complete red herring, Judge. This rule doesn't operate to exclude anything. The better argument that they have is the one that they pivot to, which is that there's a Rule 2403 balancing issue here. And the case law is well established that any risk of improper bases or inferences being drawn from this type of evidence can be cured with a simple limiting instruction, which is what we'll be using throughout this case to address similar issues.
All right, I'm going to overrule the objection and allow a limiting instruction.
Thank you.
All right, so what I'm going to do is I have made my notes and my marks on the original Court Exhibit F. I'm going to photocopy that for both sides so that that'll give you time to go back and talk to your witness.
And Your Honor, for planning purposes, obviously it takes a little bit of time to speak with our witness when we shift gears like this. Her testimony is probably going to take a fair amount of time. It might be a good idea to take lunch at this time, just because I don't want to get in here and then stop right away because of lunch.
Right, no, but you're not going to take, this can't be more than an hour, I would think.
We need a little bit of time to meet with her. It took a little bit of time with Dr. Hagan, as you know, just to go through the shift of gears, because these matters weren't determined at the motion and limine stage.
You have a position, plain? Anyone?
I don't think we need an hour to tell a witness you don't get to say these things.
Yeah, I'm going to photocopy it too for you. You can go and talk with her, and yeah, I want to get through her before we go to lunch.
Okay, Your Honor, that's fine, just as long as we can have a little bit of time to do that with her.
Yeah, I'll give you 15 minutes. It shouldn't,
Yeah, that's fine, Your Honor.
Okay.
I just didn't know if you wanted to break for lunch at noon. That was my concern, or
Yeah.
12:30. I wasn't sure.
We got snacks for him.
Okay.
We, meaning the court. All right, we'll be in a 15-minute recess.
drive? to get you to stand right here, face the clerk, and raise your right hand.
Do you swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you?
And if I can get you to step over this. Step here. Watch your stepping up.
You may proceed.
Can you please state your name for the jury?
Sure, I am Dr. Amy Klinger.
And Dr. Klinger, what do you do for a living?
I am the Director of Programs for the Educator School Safety Network.
Can you tell the jury about your education?
Sure, I have a bachelor's degree in education as well as a teaching license. I have a master's degree in curriculum and instruction, an education specialist degree, which is in reference to educational administration, which is another master's, and then I have a doctoral degree in educational administration.
And have you held any academic positions?
Yes, I was the chair as well as the director of the Educational Leadership Program at Ashland University, and I also was a full tenured professor there.
Explain to the jury what it takes to become a professor of education and administration at a university.
Well, you have to have a doctoral degree in the field of educational administration. You have to have experience as a practicing administrator, and then you have to have a particular research area or an area of expertise that you focus on.
Do you have any certifications or license?
I have a permanent teaching license. I have a gifted validation. I have a principal's license, and I also have a superintendent's license.
And the jury's heard about something called boots on the ground experience. I'm sure you're familiar with that term. Can you tell the jury about your boots on the ground experience in a school system?
Sure. Well, I started as a teacher. Then I worked in sort of quasi-administrative roles in central office as a testing coordinator and a gifted coordinator. Then I was a principal at the elementary and secondary levels. And at the university, in a university setting, I was the supervisor for administrative interns who were out in the field. And in my current position, we work directly with schools, providing training, going into the field, being in schools, working with them to assess critical safety concerns.
And so you're still providing boots on the ground work in school systems?
Yep, I'm in schools quite often.
Okay. And that's through your School Safety Network organization, correct? Could you just tell the jury just a little bit more about what that is and how long you've had that? And
Sure.
And
I'm the co-founder of the Educator School Safety Network. We are a national nonprofit. We're a little bit unique in that we come from an educational perspective, not necessarily a security or law enforcement perspective. So we provide direct training and technical assistance and consulting to educators, both administrators as well as teachers and support staff and other school stakeholders. We also do vulnerability assessments where we help schools to determine potential vulnerabilities within the facility, but also within their protocols and procedures. We also do threat assessment training to help schools to develop threat assessment teams and to implement a threat assessment process. We also do research in the field of violent threats and incidents, and then finally we develop content. As a nonprofit, we want to be able to put resources in the hands of teachers, and so we make those available to them through some of our content development.
And have you been an instructor or a trainer for the Department of Homeland Security?
Yes, through the RDPC, I was working with FEMA and DHS to develop coursework and also as an instructor to teach it. So I co-authored the courses and then worked with other FEMA and DHS instructors to deliver them.
Have you published?
I have a book that I co-authored with my partner on school safety, and then I've also published a lot of professional journals as well as academic journals, newsletters, those sorts of things, as well as scholarly articles. And then we've also published our research. Every year we publish a research report for the previous school year.
Do you present on school safety issues? nationally or internationally?
Both. We do regional conferences, but mostly we do national ones, either related to professional organizations or related to specific topics. And then we have presented internationally as well.
Your Honor, at this time, I would like to offer Dr. Amy Klinger as an expert in the field of education, administration, and school safety to testify regarding professional standards in this case.
All right, education, administration, and safety.
In school safety. School
Right.
safety, Your Honor.
Any objection?
No objection.
All right, so qualified.
Dr. Klinger, at my request, have you reviewed documents and information to determine if Dr. Parker failed to exercise any care or breached professional standards related to Ms. Werner on January 6, 2023?
Yes, I have.
Okay. Mr. Coleman, could you please publish to Dr. Klinger only the list of material that you reviewed? Let me know when you have it.
I have it.
Have it? Okay. So Dr. Klinger, didn't expect you to come in here and memorize everything that I've given you, but could you just sort of educate the jury? There are different topics on the list, and you can do it by topic, of what have you reviewed to give your opinions to this jury in this case?
I reviewed videos, body cam footage from the Sheriff's Department, as well as school board interviews with people that were involved in the incident. I have reviewed the discovery materials, both from the plaintiff as well as from the defendant, as well as the forensic services, the witness statements and incident reports. I've also reviewed materials related specifically to Newport News schools in terms of their operations plans, their employee handbooks, those sort of things, both for the district as well as for Rich Neck Elementary. I've also reviewed the depositions, all of the depositions that were taken from the various parties involved. I've reviewed the school records for the student, JT, and then in addition, I've reviewed some additional things in terms of the forensic interviews, some of the circuit court materials for that involve the aspects of the mom.
Okay. In a moment, we're going to get into your opinions, but before we do you agree to express only opinions you hold to a reasonable degree of educational and professional probability?
I do.
And having reviewed the materials, have you formed opinions regarding whether Dr. Parker failed to exercise any care or breached professional standards with respect to Ms. Werner on January 6, 2023?
I have.
Okay, and before we get to those, I just want to make sure the jury understands. Were you retained to help educate the jury about the issues in this case? Is that your understanding?
Yes.
And as an expert in school administration and school safety, have you reviewed cases for lawyers before?
Yes, I have.
And approximately how many cases have you reviewed as an expert witness?
About 25. This isn't my full-time job. I have my work at the Educator School Safety Network, but I've done about 25 cases.
And do you agree to accept cases both for and against school administrators?
Yeah. Actually, the majority of the time I am working on behalf of the plaintiff, not the school.
And this is your first time testifying in front of a jury, isn't it?
It is.
Not your first time presenting, but your first time testifying in front of a jury. Since providing expert services takes away from your work in the school safety arena, do you charge for your time to review cases?
Yes, I do.
And how much do you charge to review records?
$350 an hour.
And how much are you charging to be here today to testify in court?
$500 an hour.
And have you ever met Dr. Parker?
No, I have not.
Now we'll get to your opinions. Dr. Klinger, to a reasonable degree of educational and professional probability, do you have any opinion regarding whether Dr. Parker breached professional standards with respect to Ms. Werner on January 6, 2023?
I do.
And what is that opinion?
She did not.
And Dr. Parker, to a reasonable degree of educational and professional probability, do you have any opinion regarding whether Dr. Parker was indifferent to Ms. Werner on January 6, 2023?
I do.
And what is that opinion?
She was not.
Dr. Klinger, I'd like for you to, if you can help me, educate the jury about the roles and responsibilities of an assistant principal. Could you describe for the jury the roles and responsibilities of an assistant principal in an elementary school?
Sure. It is just that, to assist. working with the principal, but also working with the staff. It is a very collaborative role. It is working in all aspects of school operation, the instructional program, the staff relations, the professional development of staff, the daily operations and management, including safety, as well as the operational community relations side of things, working with parents, working with students, student discipline, special education. Very similar to that of a principal, but in this particular case and in most job descriptions, for an assistant principal, it says assist with. So it is very much an assistance collaborative sort of role.
Now, is school safety an area that the assistant principal assists with?
Definitely, yes.
Now, is an assistant principal the sole person responsible in a school for school safety?
Oh, absolutely not. No one is the sole person responsible for school safety. School safety is a collaborative endeavor. Every person who is in that organization has roles and responsibilities related to safety. Every single person, every staff member, students, administration, everyone that you would consider a school stakeholder has a very critical role in school safety, as well as responsibilities related to those roles.
And what is the responsibility of a school administrator such as Dr. Parker with respect to assessing a safety concern or potential threat in the school?
Can you say that again?
What is the responsibility of a school administrator such as Dr. Parker with respect to assessing a safety concern or potential threat? What do they do first?
Well, they need to establish the credibility of the threat, and that is not something that can be done alone. That's where the collaboration that I'm talking about. It's really important for an administrator to get feedback and information and disclosures from the people who are closest to the event. A school administrator cannot be everywhere. They cannot see everything. School incidents, school safety concerns do not occur in a vacuum. The world continues to spin. Other things continue to happen. The school day progresses. So it may seem easy to go, well, here's a one thing. We need to do that. But school administration is sort of spinning plates where you have a lot of different things going on and you need to be able to prioritize. And one way to do that is to get input from the staff, to get good information, to assess the plausibility, the specificity of the threat, to look at the circumstances surrounding it, and to get good intelligence, if you will, from boots on the ground.
Okay. And who does the assistant principal look to get the primary information?
You look to the people closest to the event. 911 operators and emergency responders will tell you they want to talk to the person closest to the event. They want to talk to the person directly involved. And in this case, those people had the potential to be really good resources. You had Ms. Kovac, who was a veteran teacher who had an established relationship with the student, who had worked with that student on a quite frequent basis. You had Ms. Werner, who was in the classroom, knew the student, had the student every day, had eyes on the student, what the demeanor was, what the context was, what the behaviors were. You had Mr. Rawls, who had extensive experience working with troubled students, working with students who may act out in some fashion. And so all of those people are valuable resources that can provide information to assist in evaluating the nature of a potential school safety concern.
And are teachers and people in the immediate area something called first line responders? Is that a term that's used sometimes?
Yes, and they're first line responders. They are the people that can see it, that are experiencing it, that can provide context, a really critical context of what was said, what was the demeanor, how was the person acting, what did other people say, what sort of actions are being taken. And so those first line people provide really important intelligence for an administrator to evaluate the credibility and the appropriate course of action for a response.
And does every school safety concern require an immediate aggressive response from a school administrator?
School safety concerns require an appropriate response from an administrator in the sense that it does not necessarily have to be immediate, it does not necessarily have to be aggressive, and sometimes that can be counterproductive. So if you think about the feasibility of every time a person discloses something that we go to the nth degree and we're going to immediately lock down or we're going to immediately do some dramatic response, you would never have school. You would be clearing classrooms all day long. It would be impossible for a school to function. On the other hand, school administrators have a responsibility to balance those things, to be able to get intelligence and information and make informed decisions about what the most appropriate course of action. Because think of the nature of a school where everyone runs around totally in crisis all the time because every threat is being treated exactly the same, and we're going to DEFCON 5 on every single threat. That's not safety. That is constant panic. And it also actually can make the school less safe because people become numb to it. You get into a boy who cried wolf situation where people are going, well, it's just another one of those. It's just another one of those. So the appropriate response, a measured, appropriate analysis of the information and the situation is really critical to keep people safe.
And Dr. Klinger, can you tell the jury the factors that an assistant principal must rely on to assess the potential severity of a reported student behavioral issue?
Well, in terms of looking at trying to establish or analyze the potential problem, plausibility is a big one. How plausible is it that this thing could be occurring? And that really factors into the age. I mean, in this particular case, if you're discussing a potential weapon or something of concern at a high school or a middle school level, it is much more plausible that there is the potential there that a weapon could be present. When you're discussing the plausibility of a 6-year-old having access and ability to bring a weapon to school, clearly we know at that point it was unprecedented and certainly not as plausible as you would find. So clearly that's one issue. Specificity is another, of how specific is the threat. What exactly is being said? What exactly is being disclosed? What words, what terms are being used? And then there's the context surrounding it. And again, threat assessment teaches us that we need to have the context of in what manner, under what situation, what were the circumstances. All of that kind of information is really critical. And an administrator cannot get that because they're not a mind reader. They are not clairvoyant. They cannot be everywhere. The way to get that is to get that information from the people that are seeing it, experiencing it, talking about it, and getting those reports and being able to aggregate that information so you can look at how specific is this, how plausible is it, what's the context, how credible, how severe. And all of those things have to be taken into account in order to be able to have an appropriate response.
And you talked about the assistant principal assisting with a lot. Is the assistant principal in this role triaging information?
Yeah, it's very important to be able to, because again, as I said, this doesn't occur in a vacuum. So because an administrator cannot do everything, they have to rely on the capacities and the skills and the professional judgment and the input and the context from other staff members and other people with which they work. So it's really trying to aggregate those things together because you cannot make a decision totally and completely by yourself.
In your review of the material, you've told the jury what you've reviewed. Were there any actions taken by Ms. Kovac indicating that there was not a significant level of concern on January 6th?
And I think it's an improper opinion, Your Honor, not an issue in this case as it relates to Ms. Kovac, and for the reasons I stated previously.
Can you ask your question again?
In reviewing the material, were there any actions taken by Ms. Kovac indicating that there was not a significant level of concern?
I'm going to overrule that.
Well, Ms. Kovac was present when Ms. Werner indicated initially about some defiant behavior. Ms. Kovac was told by some students that there was a concern about JT.
Don't say what, anything Ms. Kovac was told, but, or just
Oh, I'm
what your
sorry.
understanding of what action she took based on what she.
Based on the review of the materials that sorry.
So yeah, you can't tell us what other people said, just that you
Right.
relied on that information.
So based on the review of the materials, information was given that there was a concern. Ms. Kovac did not go to Dr. Parker. She did not call a lockdown. She did not call security. She instead went to investigate and spoke with the student or interacted with the student. When the student did not reveal the book bag, did not allow for the book bag to be looked at, Ms. Kovac did not call a lockdown. She did not remove the book bag. She did not remove the student. She did not remove the other students. She stayed in the classroom and after a lesson left the classroom then to report to Dr. Parker that the book bag had not been, at that point, had not been looked at. She went to lunch, the students went to recess, she came back during recess to look at the book bag. She did not call a lockdown, she didn't call security, she didn't call Mr. Rawls.
We're just reciting the experiences of Ms. Kovac from the day. I don't think it's responsive to any particular question. And the only foundation this witness would have of any of this information is in fact hearsay.
Well, she's stating from her review of the records, and that's what we're allowing her to testify to. So I'm going to overrule that. You may continue.
After it was disclosed to Ms. Kovac that the item had potentially been moved from the book bag, she observed the student at recess. And when the student did not approach her, wouldn't come up to her, and was acting in a manner that could be perceived as suspicious, she did not remove the student, she didn't move the other students, she didn't disclose immediately all that information to Dr. Parker, she did not bring security in, she did not respond in a way that would indicate there was an urgent or imminent problem at that point, and then returned to her work in testing.
In any of the material that you reviewed, did you see any information that that indicated Ms. Kovac thought it was a toy gun?
Objection, Your Honor.
Ask the question again.
In reviewing the material, did you see any indication, and you've read the statements and whatnot, that there was a thought that it was just a toy gun with this 6-year-old?
Your Honor, I'll proffer, and I think counsel would proffer, the only basis would be a statement which you ruled is inadmissible. Backdoor.
All right, I'm going to sustain that objection based on a previous ruling.
Do you want to tell the jury anything else about what you observed or from the records about Ms. Kovac's actions that day? I didn't want to cut you off.
No, just that testing resumed, she resumed her job responsibilities, and she was the person that had that relationship with JT.
And in reviewing the material, were there any actions taken by Ms. Werner indicating there was not a significant level of concern?
Ms. Werner reported to Dr. Parker going to lunch, and then, based on my review of the materials, never spoke with Dr. Parker again. There are numerous disclosures or information in the materials that indicates she was given information from students about a concern that she...
Your Honor, this is exactly what you ruled upon.
Do you have a response?
We can move on from that. Just
All right.
talk about the actions of Ms. Werner with respect to what you understand from the material with respect to what was going on in the classroom and whatnot, and
Right.
going to play to
It
the,
has to be stricken if it's sustained.
All right, I'm sorry, was that her moving on, or?
The statements
last
before-
statement.
The last statements that were objected to, if it's
All right.
sustained.
Yeah, they're stricken from the record, just like we talked about. If I strike something, you can't consider it. All right, go ahead and ask your next question.
Dr. Klinger, what is the material that you've reviewed? What actions did Ms. Werner take in the classroom once receiving information from Ms. Kovac about what other students were saying?
Well, instruction went on. The student remained in the classroom. Even though previously the materials indicate that security had been called in the past, that Mr. Rawls had been asked to assist in the past, none of that assistance was requested. No reports were made to Dr. Parker. The school day went on. The student went to recess. The first grade teachers, one of whom was Ms. Werner, observed the student, reported suspicious behavior to each other or texting it to Ms. Kovac, did not report that to Dr. Parker, did not clear the playground, did not remove the student, did not take the book bag, did not remove the other students. And so there's a lot of different opportunities for, and a lot of resources available for assistance that we know were employed in the past.
And did you see any actions taken by Ms. West indicating that she did not feel that it was a significant level of concern?
Objection, Your Honor, as to what you felt.
Sustain
Or
that.
indicated that there was not a significant level of concern? Same question I'd asked before.
Same objection before. I think the Freudian slip indicates what is being intended for.
Well, obviously, I'll disregard the previous recitation of that question and allow the second one.
I'm asking it the same way I did before with Ms. Werner, indicating that, did you see in the material any actions taken by Ms. West indicating there was not a significant level of concern?
Ms. West took a student, a different student who had a disciplinary behavioral issue, to Dr. Parker during recess and did not make any discussion of what was observed at recess, the suspicious behavior, those different behaviors that were being observed at that point. She asked Ms. Werner to watch her class and bring them in, so that doubled the size of the number of students that Ms. Werner was supposed to be supervising, which would indicate she felt that was appropriate to do, to ask her to do that.
Objection, Your Honor, same thing.
All right. Overruled. Continue.
Anything else
No.
with Ms. West? Did you, in your material that you reviewed, you read the deposition testimony, see anything to indicate that Ms. West actually encountered Dr. Parker in the building?
She brought a student to, a different student that had disciplinary concerns to Dr. Parker and was involved in a face-to-face discussion with her, but that discussion did not include any disclosures about the behaviors of JT at recess.
And is that something you would have expected if there was a significant level of concern, that there had been a discussion at that time?
Yeah, I think it's important that this was an evolving situation, and one critical element is to get updates on what's happening, what's going on, what has changed, if anything, and those updates were not occurring.
And same with Mr. Rawls. So you've read all the deposition testimony and the statements of Mr. Rawls and whatnot. And is there anything, any actions taken by Mr. Rawls indicating that there was not a significant level of concern?
When Mr. Rawls spoke with the student R after recess, he received information, more information about JT, and again, did not feel that it was necessary
Objection,
to,
Your Honor. Did not feel.
sorry,
Or you could just say what he did not do. And so-
he did not remove the student. He did not clear the classroom. He did not call security, call for assistance, call a lockdown. All of those things are capabilities and resources that were present to any of these individuals.
And in the material review, did you see that at some point there was a discussion between Dr. Parker and Mr. Rawls about body searching the student? And do you have, what is your understanding about decisions made in that regard?
Generally, or in this specific?
In this specific case?
There
Without
wasn't.
saying what someone said.
There was a discussion about an option for a search of the student, and the approach was cautious, as it would be appropriate to do so. And there was a determination made that when the parent was present, that search could continue.
Okay. And why would it be, in your experience, that a search of a student is something that could be cautious if you're looking for a weapon?
Well, we should always be concerned about the search of a student, regardless of their age. But certainly, and that is not something that any school administrator should enter into lightly. But I think it's really important to think about, this is a 6-year-old, this is a little kid, and we are going to do just at will start doing body searches on kids. That's not any kind of endeavor that anyone should do, especially when they don't have a good amount of intelligence or information that would support that at that point.
Dr. Klinger, do you have any opinion on whether Dr. Parker could have foreseen JT's actions that day based on the information that she had?
I think it would be difficult for anyone to have foreseen that. I think the actions of everyone involved indicate that they were doing an analysis, but yet that they did not perceive this to be a plausible, imminent threat, both the behaviors as well as the actions, because it is a 6-year-old having access to a weapon and bringing it to school, and it is largely unthinkable and certainly unprecedented in terms of the outcome.
And Dr. Klinger, did you review any protocols of the Newport News school system in your review of the materials?
The crisis plan for Newport News, yes.
And did your review of any protocol change your opinions in the case in any way about assessing the threat or the school safety concern?
No, the protocols of a crisis plan provide a framework. They provide guidelines for what people should be doing. But they also have to, and in this particular case, they give people latitude for professional judgment. When a crisis plan becomes so prescriptive that you must do this, you must do this, you must do this, it really makes it actually more ineffective. So it is critical that people have the ability to use the tools that we've talked about and that use the judgment that we've talked about and incorporate or factor in the circumstances that we've talked about when they're making that decision.
And Dr. Klinger, are all of your opinions and conclusions you've provided to the jury today held within a reasonable degree of educational and professional probability?
Yes.
Please answer any questions Mr. Beniozen has.
Cross-examination?
Yes, Your Honor.
No, object. It's another roadmap. Object.
You can have roadmaps for your witnesses, but not for theirs.
All right. Good afternoon.
Hi.
We're going to talk about 3 things, okay? We're going to talk about getting good information. We're going to talk about the threat. And then we're going to talk about over-under, okay? You understand what that term over-under means?
Mm-hmm.
And in your report, you talk about overreactions and underreactions. Is that correct?
Yes.
And it's also a term used in the gambling world, over-under.
Can't speak to that, but yes.
All right, so let's take it one by one. Let's start with getting good information. You talked about in direct how teachers are first-line responders, true?
Teachers and support staff,
First line,
yes.
which means that there's a second line.
Mm-hmm.
Is that right?
Yes.
Second line being the assistant principal, true?
Well, it depends on the hierarchy of the school. I mean, some schools don't have assistant principals, but if you want to say administration globally, yes.
And in this case, Rich Neck did have an assistant principal, true? And that assistant principal was Dr. Ebony Parker.
Correct.
And you mentioned before about getting good information and how first-line responders are closest to the information. Is that correct?
Yes.
And on this day, it sounds like you're critiquing the information that was passed along to Dr. Parker. Am I interpreting your testimony correctly, that you're critiquing what people shared with Dr. Parker?
Well, I think the nature of what is shared is relevant and important to it. I mean, we have to understand this is a tragic, horrific event for every single person involved. So critique may not be the word, but I think clearly we have to evaluate the nature of the information that was given to her.
Right. And getting good information is a two-way street. Fair?
Mm-hmm.
Is that yes?
Yes, I'm sorry. Yeah, I know. I should know better. Sorry.
In other words, you don't think an assistant principal should just sit in their armchair, wait for people to tell them information, and then just decide what to do based on what they tell them, right?
I don't know that that's what happened in this case because there were other instances going on. There were when Ms. West brought her student and then sometime in the afternoon cried out for help, and Dr. Parker came because two students were fighting in the hallway. So I wouldn't say that she never got out of her chair because clearly she provided assistance when it was asked for.
Okay, so let's take it step by step.
Okay.
You agree that an assistant principal can't just sit in their chair and wait for information to come to them, true?
I think that an assistant principal can have a reasonable expectation that if there's something she needs to know, people will tell her.
Okay. And so she should just assume everything's okay unless somebody comes and tells her more.
Well, your option then is that you have to go door to door and ask everybody, hey, is everything okay here? Is there anything I should know? Is there anything? And that's not really feasible for the management of the school.
Really, really happy you said that, actually. Really, really happy you said that. So let's talk about going door to door. In this context, Ms. Kovac told Dr. Parker explicitly about a gun and a specific student, true?
At what point?
Around noon.
Prior to going to lunch?
Correct, around noon.
There was a discussion of a weapon.
It wasn't a gun in his book bag.
That's not what you asked me. You asked me what she told.
Right, that's at noon, around noon, did Ms. Kovac go into Dr. Ebony Parker's office and report that students were saying that JT had a gun in his book bag?
My understanding in the review of the materials is that she said that the students reported he had a weapon.
And your review of the materials, I hope, included the written statement of Dr. Parker?
Mm-hmm.
Is that a yes?
Yes.
Okay. So I'm going to go ahead and show you that. It's been pre-marked as Plaintiff's Exhibit 2, Your Honor. You were provided this written statement written by Dr. Ebony Parker.
Yes.
It has her name on the bottom there. Do you see that?
Correct.
Permission to publish, Your Honor.
Any objection?
Just 1 second.
No objection. I'm sorry, you said no objection, correct?
No objection.
Okay, thank you.
Your Honor, I'm just double checking that there aren't any references to the child's full name.
It does have the child's name in it, so
What's that?
it has the child's name and it has.
All right, so we'll block that.
Permission to publish, Your Honor.
May without objection.
Thank you. So, in the materials that you were provided, Dr. Klinger, this is the sentence I was reading to you. That around noon, Ms. Kovac came into my office and reported that the students were saying the student, JT, had a gun in his book bag. Do you see that?
Mm-hmm.
Is that a yes?
Yes.
And so, when you said earlier, you can't go around every classroom, knocking on every door, searching every bag. You recall that testimony?
Well, I was speaking in terms, your question was about finding out if everything was okay. It wasn't about searching bags.
Okay. Well, in this case, there was a specific child reported to have had a gun in his book bag. True?
Yes.
And because communication is a two-way street and getting in good information is a two-way street, you would expect the assistant principal to attempt to get some information herself. True?
Well, according to that statement and the materials that I read, there was a discussion between Ms. Kovac, who was a seasoned educator with a relationship with the student, third in line in the chain of command. There was a discussion between her and Dr. Parker, and Ms. Kovac indicated she was going to go and look in the book bag.
And based upon the information that you received, that she checked the book bag, there was nothing in the book bag, but that there was a report that there was something put in his pocket. True?
That was a report made later, yes.
And you're familiar that in response, Dr. Parker observed that the child's pockets were too little. True?
That's in the materials that's alleged.
And so when we're talking about getting good information, to make sure that we're on the same page regarding good information, when we talk about Miss West and Miss West bringing a child to Dr. Parker, do you recall your previous testimony about that?
She brought him to the office, yes.
In fact, according to Dr. Parker left her office and went and retrieved the child. True?
Which child are we speaking of?
The one that was eloping.
Yes.
So Dr. Parker at some point in time did decide, I'm going to leave my chair and I'm going to go deal with a student.
Yes. I believe she also left her chair when the students had the altercation in the hallway, and also to talk with Miss West about the student she brought in from the playground.
And during those times in which Dr. Parker left her chair, did she go and inquire with the student, JT?
Specifically to the student,
Yes.
JT, or about the student?
To the student, JT?
No.
And you mentioned about how when law enforcement gets phone calls on dispatch, they always want to get information straight from the source. Do you recall that?
Mm-hmm.
Is it a yes?
Yes.
And when we talk about getting information straight from the source, in this context, there were two girls who reported to Ms. Kovac who reported to Dr. Parker, true?
Yes.
And at what point in the day did Dr. Parker leave her desk to go talk to girl number one?
Well, in her testimony, Ms. Kovac indicates she didn't know who they were.
Not my question. At what point in the day did Dr. Parker leave her desk to go talk to girl number one?
How could she if she doesn't know who girl number one is? Because Ms. Kovac doesn't know who girl number one is because she didn't ask her name and didn't get the information, which makes it difficult to investigate
So
if you don't know who the student is.
So Dr. Parker's obligation there stops because she doesn't get good information, so she can sit back and just rely upon the fact that she didn't get good information.
That's not what I said. I said it would be difficult to interview a student that you don't know who that student is.
You mentioned earlier that there are, what, 40 first grade students? And 20 in Mrs. Warner's class?
I
20?
never said how many students there were.
She didn't testify.
Earlier you had
Okay,
talked.
hey, hold on, I've got to sustain that objection, rephrase.
Earlier, you had talked about how at some point in time, one of the teachers was looking after two classroom sets of students. True?
Correct. I said Ms. Werner had double the students. I didn't say the number.
Okay. And so, just so we're on the same page, Dr. Parker never went and attempted to talk to a girl or two girls. True?
The ones that disclosed to Ms. Kovac you're speaking of?
Yes.
She did not because she didn't know their identity.
You say because she didn't know her identity. You've never spoken to Dr. Parker, have you?
No, I have not.
Okay, so when you're trying to say what Dr. Parker knew or didn't know, it's conjecture. You don't. She's never told you she didn't know the identity.
Well, the materials say that Ms. Kovac did not.
But
So I don't know how Dr. Parker would be able to know who Ms. Kovac spoke with if she didn't see her speaking with the two students and Mrs. Kovac didn't know the name of the two students. I don't know how Dr. Parker would know that, but you're right, I don't know that.
Okay, so you do not know whether Dr. Parker knew or did not know.
I do know that Ms. Kovac did not know the names of those students, and she didn't inquire or bring them to Dr. Parker so that Dr. Parker could speak to them.
Dr. Klinger, I know this is your first time in the courtroom. Just asking that you answer my questions. I'll be happy to let you expand, but I just want to make sure that we're not talking past each other.
Most certainly.
So, you do not know, because Dr. Parker never communicated to you, whether she knew or didn't know who those two girls were.
That is correct.
Okay. And when we go further and talk about getting good information, at some point in time when it's reported to Dr. Parker that there's a belief that there's something in his pocket, we talked about that a moment ago, correct?
Correct.
At that point in time, you'd agree that there's still at least a possibility that there's a firearm on campus, true?
Yes.
And at that point in time, to address the possibility of a firearm, did Dr. Parker request any specific information from anybody to be conveyed to her?
Specific information from anyone?
Correct. Did she say, will you go and search the person? Or will you go and talk to JT? Or why don't I go and talk to JT? Did she request any specific information in order to make the decision of what to do about a possible firearm on campus?
In the review of the materials, it would appear that that was a discussion that was had with Ms. Kovac and also with Mr. Rawls.
But that was, so let's get our timeline right. Ms. Kovac looks at the book bag, no gun in the book bag. They go and talk. That's when the comment is about little pockets, right?
Yes.
And that's about 12:20 in the afternoon, true?
I don't have a timestamp on that, so I can't speak to that.
And then Mr. Rawls comes and talks to her at 1:40 in the afternoon. Isn't that correct?
Again, that's my understanding, but some of the times seem to be a little contradictory in my review of the materials. Some of the times, depending on the statements, were a little bit off, so I don't want to say 1:40 with certainty.
Let's say it was 1:40.
It was after recess.
Let's say it was 1:40. That would mean that for about an hour, Dr. Parker was aware that there was the possibility of a firearm on campus at Rich Neck Elementary. True?
That there was the possibility that JT had what students were characterizing as a weapon and a gun.
Is that different than what I had asked you?
Yes, you said a firearm. Typically, students would not disclose a firearm. They would say a gun, meaning a squirt gun, a gun, meaning a Nerf gun, a gun, meaning bullets. Again, in my experience, students, I'm sure there are some, but very young elementary students don't typically use technical terms like firearms and things like that.
But we just looked at the report from Miss Parker herself, Dr. Parker, Exhibit 2, and it used the word gun.
Yes.
Okay.
I'm not disputing that.
And it didn't say toy gun. True?
The students
This-
said gun, yes.
And this report from Dr. Parker used the word gun, not toy gun, true?
That's what the report says, yes.
Okay. And so, let's talk about the threat at that point. You mentioned earlier about this isn't something that would be foreseeable. Do you recall that?
Yes.
Your Honor, I'd like to, just for demonstrative purposes, it's just a scale.
Object, Your Honor.
I can't see what that is. Okay, I'm not exactly clear where you're going with that.
Object, Your Honor. It's another diagram drawn by Mr. Beniozen during trial.
I don't know where he's going yet. Continuing objection until we see where it's going.
You mentioned not foreseeable, correct?
Yes.
All right. As of, don't publish this yet, please. At that point in time, we're talking well, let's actually start before. January 6th in the morning, before JT comes to school. What, in your expert opinion on the issue of foreseeability, what was the foreseeability of a gun on campus at Rich Neck Elementary School, on a scale of 0 to 10?
Incorporating all students, K through 5?
Yes.
So every student there.
What was the foreseeability of a gun on campus? 0 to 10.
Inclusive of the entire population of the school.
Yes.
Probably a 1.
So it's not like it's off the radar, true?
Correct. Now, if you want, well, I can't tell you what to ask me, but that's why I ask about the number of students. The younger they go, the younger they are, the lower that number would be.
Okay, but when we talk about a firearm on campus, we're talking about a risk, a threat, true?
Yes.
And that's because a firearm on campus at an elementary school isn't just a risk of an active shooter. You'd agree with that, right?
Yes.
There's a risk of an accidental shooting, correct?
Yes.
And so any firearm on campus is a threat, true?
Yes.
And so on a scale of 1 to 10 before January 6th, it's a 1, true?
Before January 6th?
Yeah.
I thought you said that
On the
morning.
the
of.
morning of.
I thought,
That's what I mean.
okay. Yes.
And
Overrule the objection. You're using this for demonstrative purposes only?
Yes, Judge.
All right, you may proceed.
go ahead and publish read. And you tell me if I'm misstating, okay? Say foreseeability of gun on campus. Is that right?
In a K-5 environment, correct? You're asking me? Yeah,
Is that correct?
that's correct.
And we agreed that this equals a threat, at least some threat.
The foreseeability equals a threat?
A gun on campus.
The gun equals a threat, yes.
Okay, and so we're at a 1. True?
Based on what you described to me, yes.
So we'll call it 9 a.m. 1/6/23. So, you're familiar with the Rich Neck Handbook, correct?
Yes.
And you're familiar that the Rich Neck Handbook actually contemplates a level 3 incident involving the possession of a firearm, true?
Yes.
How does that change your determination of foreseeability? Does that make it more foreseeable because they've thought about it in the manual that it could happen, or does it make it less foreseeable?
I'm sorry, I don't mean to be, I'm not sure that I understand what you're asking me.
Sure. In the context of Rich Neck Elementary specifically, there is a handbook that calls a Tier 3 threat assessment, and that is if there's a possession of a weapon. Do you recall that?
Yes, I believe that's for the whole district, though, not just specifically for Rich Neck. Is that correct? Your understanding as well?
And Your Honor, if he's going to question her, he can show it to her.
Happy to show it to her.
Show it, publish it to her. I'm not sure it's in evidence, but.
You can show her, yeah,
Okay.
just don't publish it. 'cause I don't
This
think-
is already in evidence as
Okay, if
exhibit
it already is, it's the
108.
one that is.
So this is permission to publish?
Yeah, if you can just read the exhibit number on there.
This is exhibit 108. You see the Rich Neck Elementary School staff handbook?
Yes, I do.
And section 3, we talk about level behaviors. Get into it. There's a specific discussion of a possession of a weapon. Do you see that?
Yeah, can you slide that down so that I can't see all of what the title, there you go, thank you. see it now.
Possession of a firearm, or a weapon, excuse me.
Yes, those being behaviors that need to be immediately reported to an administrator.
Understood. And in this context, in light of Rich Neck Elementary's specific understanding that that is a student behavior, how does that increase or decrease your foreseeability analysis? Does it make it more or less likely, in your view, that there's a gun on campus if they've already talked about the possibility of a gun on campus?
No, I would say that most likely that's part of a larger comprehensive plan that was supposed to be appropriate for all levels, including secondary levels. And also, this is a K-5 building, it's not a pre-K, so you have older students in the building as well.
Understood. So then let's talk about 1 through 10. When Kovac tells Parker, gun, it was a 1 at 9 o'clock in the morning. What is it at the time that Kovac tells Parker there's a gun?
Well, it's higher than a 1 because you have that word that's being used. But there also is the plausibility factor, the factor of what the student said. Unfortunately, there were no statements taken specifically from the students.
Dr. Parker didn't take any statements. of the
Right, so
student.
we don't know who the students are. We
Right.
don't know. So we only have what Ms. Kovac relates. So she relates, or Dr. Parker relates, that they used the word gun.
So 1 out of 10, higher than a 1. What is it?
Yes. At this point, I would say, given the fact that Ms. Werner had just been there and indicated that JT was being defiant, but did not indicate that he was acting strange around his book bag, or that he was showing things to kids, or that kids were frightened, or any of those things, it's probably a 2 or a 3 at this point.
Okay. Then we have a moment in time, as we talked about, where Kovac says, no gun in backpack, put something in pocket. Is that right? Is that true?
We have a moment where Ms. Kovac has looked in the backpack and there is no gun, and Ms. Werner has texted Ms. Kovac and told her that he put something in his pocket. Dr. Parker did not know that until Ms. Kovac told her.
Right. So that's the moment I'm talking about. The moment where Kovac says, no gun in the backpack, but there's a report that he put something in his pocket. This little pockets moment. You understand where I am in the timeline?
Yes, I do.
Scale of 1 to 10. What's the foreseeability?
I think we're still basically in the 2 to 3. And actually thinking of the size of an actual firearm.
So you're still at a 2 to 3.
Yeah.
All right.
And may I qualify what or clarify what you're saying? You're saying based purely on this information, not all the other information that was observed by other people that was not disclosed to Dr. Parker, is that correct?
Well, ultimately, we're asking, and the question in this case, as you understand it, is Dr. Parker's actions, correct?
Right, but
That's-
you're asking me to give you this numerical judgment based on purely the information you're writing on the paper, correct?
Well, yes, if
Okay.
there's something more that you think should be considered, you're happy to tell, I'm welcome it.
Mm-hmm.
When you said earlier, it's unprecedented, it's not foreseeable, I'm trying to get an understanding of how these different pieces of information may affect that.
Sure.
Is that fair?
Yeah.
Okay. So we're at a 2 to 3 still after the conversation about something in the pocket. Then the next discussion, as I recall it, and you tell me if I'm wrong, the next discussion is when there is a question from Mr. Sims to Dr. Parker about, did we search the person? Am I correct?
Yes.
Okay. And so we talked about context clues, essentially. You know, we have to read into the conduct of staff members to get an indication of how credible a threat is. Do you recall that testimony in your direct?
No, that's not what I said. I said context, not context clues.
Oh, okay.
Well, I'm just
I'll-
saying it's not the same thing.
Okay, so we'll talk about context. At this point in time, when Mr. Sims comes to Dr. Parker, there's still a possibility of a gun on campus, true?
The possibility, yes.
A 2 to 3 possibility.
Yes.
And Mr. Sims is now saying, have you searched the person? True?
To Dr. Parker?
Yes.
Yes.
Okay. And so at that point in time, when Mr. Sims is asking, did you search JT, how does that affect the foreseeability? I mean, it's a teacher saying, hey, we need to check the kid.
Well, I believe Mr. Sims was relating information. I think he was covering the office at the time. So I believe he was more of an intermediary than a person urgently raising a concern, but that may be up for interpretation. But he does, you're asking me, did he speak to Dr. Parker about that? Did he ask that? Or what? Maybe you can ask me again with that caveat.
Sure. When Mr. Sims goes to Dr. Parker and says, did you search the person, in light of the fact that there is still a possibility of a gun on campus, what is the foreseeability at that point in time in your expert opinion? 2 to 3, more than 2 to 3, less than 2 to 3?
Well, it's easy now to go, boy, we should, but in that context, with the fact it's a 6-year-old, with the fact that Dr. Parker is not privy to all of the subtleties and the context that you alluded to, and given the fact that now we are looking for something, one student R indicates bullets, and so we now haven't really elevated that a great deal.
So 2 to 3?
Yeah. I mean, if we wanted to do a parallel exercise where we were talking about a high school student or a middle school student, clearly we would be talking different things, but I'm answering your questions specifically for an elementary, kindergarten, 6-year-old.
I know you're saying that, and that's this idea that a high school student may more intentionally fire a gun. Is that fair?
I'm saying a high school student most likely would have greater access to a gun, would have capabilities to use it, would have the capability or the forethought to bring it for threatening purposes, which might speak to your concern about safety. I mean, if we want to just go statistically, how many 6-year-olds have you seen walking around with a gun versus how many 17-year-olds have you heard having a firearm?
If you want to talk statistically, we can talk about the CDC's investigation into accidental shootings in elementary school students in 2023. Did you review that finding of the CDC?
For this case? No.
Okay. You are aware, because you work with the Department of Homeland Security, that the CDC did perform an investigation into the prevalence of accidental shootings in minors, specifically children of the age of JT, correct? You're aware of that as an expert, aren't you?
Aware of that study or aware of it in this context? I did not review it for this case, and this was not You were asking me questions not about an accidental shooting. You were asking me about foreseeability.
Foreseeability of a threat on campus
Yes.
if there's a gun, true?
Yes.
And whenever there's a gun, especially at an elementary school, an accidental shooting is a threat, true?
Yes.
And so, at the time that Mr. Sims goes and talks to Dr. Parker and is continuing to ask about a search of the person, it's still, in your view, it's a 2 to 3 foreseeability of a threat at that time.
For a 6-year-old.
Just asking you about a gun on campus, 2 to 3, more, less.
Well, I think you're asking me to make a unilateral statement, and I'm trying to provide the context that you referred to. And the context being the foreseeability of a 6-year-old having a firearm.
So it's okay to just disbelieve it because
That's not what I said. You're asking me about foreseeability. You didn't ask me about response. You didn't ask me about attitude. You asked me about foreseeability.
We'll get there.
So foreseeability of a 6-year-old is in the low end of your scale.
Okay. So we're at a 2 to 3.
Yes.
After Mr. Sims leaves Dr. Parker's office, there is then another conversation with Mr. Rawls, correct?
Yes.
And this is the conversation I think that you and Mr. Rawls during that requests, oh, that's really bad. Requests to search, true?
Who are you referring that Mr. Rawls is talking to? You're done with Mr. Sims, right? You're talking with Dr. Parker, correct?
Correct.
I just want to be clear so I can answer it correctly.
So Mr. Rawls requests to Dr. Parker to search the student, true?
There is a discussion about searching.
Okay.
Yes.
And that's now the second discussion about searching the student. Mr. Sims, then Mr. Rawls, true?
The first one was a informational, has he been searched? This one was a discussion about searching.
And, okay. And so, at this point in time, foreseeability, 2 out of 3, more, less?
Well, I think you're equating the discussion of searching with somehow urgency or more likelihood. So I don't see that there is a, again, significantly higher likelihood. It is still quite implausible, even though we know it happened. It is still not a lot of specific information. It's still all the things that we talked about. So yeah, we're still in the lower end. I think Dr. Parker and Mr. Rawls' discussion centered on the plausibility, but also on the caution through which an administrator should undertake a body search of a 6-year-old. And so there wasn't a refusal to search. There was the decision that it needed to be done with parent, not necessarily permission, but parent involvement.
So 2 to 3, or is it more?
I don't think it goes up a lot more, no. And especially considering that Mr. Rawls has experience with
it go up at all?
troubled students.
Objection, Your Honor, he's cutting her off.
I mean, I just asked more than 2 to 3.
All right, so we can answer his question.
Is it more than 2 to 3? You said not much more. How
No.
much more?
3, there.
3, all right. We moved a little. And you're talking about this communication process with the assistant principal, Dr. Parker, and the staff members, correct?
Yes.
And in your book titled "Keep Students Safe Every Day," that's the title, correct?
No, it's keeping students safe every day.
Sorry, I missed the ing. You'd agree that a crisis event occurs in a school, there needs to be effective communication, correct?
That is correct.
And that the assistant principal is the leader in that regard, correct?
I don't say that in the book. The assistant principal is the leader in that regard?
Do you,
I don't remember writing that.
all right, is the assistant principal a school leader, to be clear, specific, and timely with communication?
An assistant principal is one of the school leaders, and in the crisis plan is one of 3 school leaders.
And in this context, at 1:40 in the afternoon, if you accept my representation, that that's when this conversation occurred, it was a 3, that there is still 3 likelihood that there is a gun on campus. True?
Based on what you have asked me to assign to it, yes.
Okay. All right. And when we say a 3 likelihood, and you talked earlier about, I think you said you have to assess whether to search the person, the boy, or not, given his age and other surrounding circumstances. Do you recall that?
I don't know that I said assess, but I might have.
So, I told you earlier the last thing we talked about was over, under. Do you recall that?
Yes, I do.
And when we say over, we're talking about what's an overreaction to a gun on campus? What's an underreaction to a gun on campus? True?
Right. When I spoke about it in an overreaction, underreaction to a crisis event. But yes, we could specifically talk about to a gun on campus.
Well, that's what we're talking about in this case, aren't we?
I just want to be clear that when I spoke about it, I speak about it in general.
So what is an overreaction to a gun on campus at an elementary school? What's an overreaction?
Well, I think that when you want an example of it, you mean?
Yeah, I mean, you're saying you have to weigh the balancing test. What possibly could be an overreaction to a gun on campus?
So you want me to take it to the biggest overreaction I can think of?
Sure.
That would be when a student indicates that another child has something.
Yeah, but we're
Weapon.
talking about overreaction, underreaction in terms of responses, correct?
Are you asking me when it is already proven that there is a weapon on campus, or when there is a suspicion of a gun or a weapon on campus?
Which one applies here?
Which one applies to your questioning?
Which one applies to this case? A suspicion or proven? In your view,
There was a suspicion that the student had a weapon of some sort.
of a gun.
Students used the word gun, yes.
She used the word gun.
In her statement, yes.
So there's a suspicion of a gun. So let's use that circumstance.
Yep.
There's a suspicion of a gun on campus. The assistant principal recognizes there's a suspicion of a gun, and for 2 hours, the foreseeability that the gun remains on campus is not 0. It's something more than 0. That's what we've just gone through. True?
Yes.
What's an overreaction in that context?
In a elementary school where there is the suspicion that a 6-year-old has something.
We're not talking about something. We're talking about a gun.
That a 6-year-old has a weapon that students
talking
have
about a gun.
categorized as a gun.
We're talking about a gun, man.
Do you want me?
What is an overreaction to a gun?
An example of an overreaction is that when a student says, student X has a gun, that we call a lockdown, we have an active shooter response, we search the kid, we put him down, we put him in cuffs, we drag him off until we can figure out that he had a Nerf gun or a squirt gun or a firearm.
So you agree that Mrs. Werner wasn't expected to just drag the kid out of class, call a lockdown, and do all this stuff? That would be an overreaction.
An underreaction
Hey,
would be
stay
to
with my
leave him
question.
in the student,
Stay
in
with
the
my
class.
Stay with my question. You agree with that statement that I made, correct?
No, I do not. An overreaction, it would be an overreaction to tackle the student, get the police, yes, all based on somebody said he has a weapon or what small children call a gun.
So let's talk about underreactions. Underreaction is an assistant principal not calling 911. True.
Well, can I finish answering your previous question?
You didn't answer my previous question. You went on to your own question.
Well, no, I was trying to answer the question of you asked me about an overreaction, and then you brought up Ms. Werner as an overreaction that she didn't drag him out.
Correct.
Did you? That's what I understood you to say.
And you agreed that you wouldn't expect her to do that.
But a student can be removed from a classroom without being dragged, kicking and screaming.
Right.
A student can be isolated. A book bag can be moved without it becoming an altercation or an aggressive or violent incident.
All things
That would be a more appropriate reaction. So I just wanted to clarify the overreaction that you asked about.
all things that Dr. Parker did not do. True.
All things that Ms. Werner did not do either, or Ms. Kovac didn't do either, or Mr. Rawls didn't do either, because in their judgment, it was not an appropriate measure at that point.
Let's answer my question.
Okay.
All things that Dr. Parker did not do. True?
All things, as in remove him from the room?
Correct.
Yes.
Okay. Now, when you've heard this statement, I presume, in life about sounding the alarm. You understand what that means?
Yes.
Okay. And so in this instance, there was a request, there was information that was conveyed all day that we talked about in terms of foreseeability to Dr. Parker. True?
There was limited information that was conveyed to Dr. Parker, but not all the information that was available. The materials suggest there was additional information she wasn't privy to.
Information was conveyed.
Some information, yes.
Sufficient for Dr. Parker to understand that there was a gun on campus. True? That there was
Sufficient?
Sufficient for her to suspect there was a gun at Rich Neck Elementary School. We talked about suspicion.
Sufficient for her to understand that there was a concern about the potential of a gun on campus.
The information, start this way, some information was conveyed by Ms. Kovac to Dr. Parker, true?
Yes.
And again from Ms. Kovac to Dr. Parker, correct?
Yes.
And then from Mr. Sims, at least a question to Dr. Parker, correct?
Yes.
And then from Mr. Rawls to Dr. Parker, correct?
Correct.
So the individual who was in the position that was aggregating the information in this circumstance was Dr. Parker. You agree?
Aggregating as in receiving that information?
Yes.
Yes.
How much more do you have, Mr. Benioff?
I think nothing, just looking at this now. That's all I have now.
Please stand for the jury. Nine jurors in the box.
Be seated.
I'm going to show you Exhibit 108. Mr. Beniozen showed it to you in his cross-examination, the Rich Neck Elementary School Handbook. It's Exhibit 108 at page 2.
Okay.
And give you a minute to look at it.
Okay.
Take your time.
Is it possible to make it just a tiny bit bigger? Thank you. Can you scroll? There you go. Thank you.
We'll start on the page 1087.
Okay.
Your Honor, I think we can publish it to the jury since they've already seen it. Okay, just making sure. Dr. Klinger.
Have it up on our screens yet.
Oh, I'm
It's on
sorry.
that screen.
Dr. Klinger, you see the paragraph beginning with discipline is the initial responsibility?
Yes.
And is that, I don't know that you would review this document before today. Reviewing it now, do you see that it says that discipline is the initial responsibility of the teacher?
Yes, I do.
And as a teacher, the first line responder, which you explained to the jury
Correct.
before? We'll go to the second page. I think Mr. Beniozen asked you some questions about level 3 behaviors. You recall those
Yes.
questions?
Mhm.
And on the left-hand side, there's a list of student behaviors, one of which is possession of a firearm. And
Yes.
based on your review of the material, just to be clear, did you see any evidence that there was a confirmed possession of a firearm before the event that happened in the
Objection,
afternoon?
Your Honor.
What's the objection?
Your Honor, she's saying based on your review of the information, did you determine that there was a confirmed determination of a firearm? How is that helpful to the juror, the trier of fact? The question is whether or not Dr. Parker reached the standard of care. That's what she was proffered to do. Reaching a conclusion that's the state of mind of the person is irrelevant.
You have a response?
I'll try to rephrase it a little
So
bit.
sustained, allow you to rephrase.
Yeah, did you review any information in the records that you reviewed that there was a confirmed firearm or weapon before Ms. Werner was shot? It's a simple question.
Objection, Your Honor. I think it's still impermissible as it relates to hearsay. If she's saying, did you review something? Everything that she's reviewed is hearsay. The question is, did she reach her own conclusions?
I'm going to overrule that. I think you can answer that.
I didn't see anything in my review of the materials that indicated there was confirmation of a firearm.
Okay. And then the next steps that were discussed with you, it says secure students and ensure safety. Do you see that? And that's for the teacher to do, correct? Is that your understanding?
Objection leading.
All right. That's sustained. You rephrase.
In reviewing the next steps, do you see where it says secure students and ensure safety?
Objection leading.
Can you rephrase it in a non-leading manner, please?
In your review, you've reviewed the next steps, correct?
Yes, I have.
And based on your review of the material, did you see in the records where Ms. Werner secured the students that day?
No, there's no evidence of that in the materials that I reviewed.
Okay. Did Ms. Werner give notice to an administrator immediately, Dr. Parker?
Of this level of, these levels of infraction, no.
And Dr. Klinger, we can take that down. Mr. Beniozen showed you a statement by Dr. Parker after the event, correct? Do you recall
Yes,
that?
yes.
That is information that you had reviewed before? Had you reviewed the information before?
It was in the materials that I saw, yes.
And you reviewed it again today with Mr. Beniazin?
Yes.
Does any of that change the opinions that you've already told the jury? You're reviewing again today with Mr. Beniazin, Dr. Parker's statement?
No.
And Mr. Beniazin was able to draw some numbers and circle things with you and then go through information in the records that you've reviewed in the deposition testimony?
Yes.
Did any of the discussion about the numbers and what numbers you would circle change your opinions?
You mean in terms of doing that exercise with
Yes.
him? No.
And Mr. Beniazin asked you about Mr. Raw's discussion with Dr. Parker about body searching the student.
Yes.
And you had reviewed Mr. Raw's deposition?
Yes, I have.
And had you also reviewed other statements by Mr. Rawls to the school board?
Yes.
And so going through that material today, did that change any of your opinions in the case?
No.
Dr. Klinger, on cross-examination, Mr. Beniazin asked you whether you recalled specific statements that Amy Kovac made to Dr. Parker before the shooting.
Yes, he did.
And do you recall when Mr. Beniazin asked you, did Ms. Kovac tell Dr. Parker explicitly about a gun and a specific student?
Did he ask me
Do
that?
you recall when he asked
Yes,
you
I
that?
do. I'm sorry.
Sitting here, are you able to remember exactly word for word what Amy Kovac reported to Dr. Parker?
No, because it appeared to be, I mean, there was the general suggestion, the discussion of a weapon, but even within the materials there is not clarity on that.
When you reviewed the records, did you review body-worn camera video depicting Ms. Kovac's interview with police after the shooting?
Yes, I did.
And would reviewing that video refresh your recollection of what Amy Kovac said to Dr. Parker regarding whether Ms. Kovac thought JT had a gun?
Yes.
Can you show?
We object to the line of questioning, Your Honor.
Yeah,
He opened the door, Your Honor. We can look at the body cam video outside the presence of the jury, but he opened the door.
how did he open the door?
He asked her, yeah, and again, this is crossing over into an argument that Mr. Hogan's already made. I'm happy for him to interject because we're crossing over in two witnesses right now, or I can keep going, whatever the court prefers.
Yeah, I'm going to sustain the objection. She can't refresh a witness's testimony with another witness's testimony. So I'm going to sustain the objection.
Judge, if I could respond briefly to this point, and it may be appropriate to raise these arguments in a sidebar.
No, you can make it after she steps off the stand, but no, I mean, I've ruled on that.
Just one moment, Your Honor. No further questions.
All right. Anything?
2 or 3.
Limited to redirect.
Yes, Judge. If we can go to the IP vote, please. You were shown this page, Dr. Klinger, correct?
Correct.
And opposing counsel had highlighted this first part, discipline is the initial responsibility of the teacher, correct?
Correct.
But the sentence goes on to say, thus, in expectations of Tier 1, correct?
Well, I can't see it, but yes, I believe that's what it says. In my version, it's zoomed out. Okay.
It goes.
Thank you.
It specifies Tier 1, correct?
It's a tier 1 expectation, yes.
Okay. in level 2, it talks about referral to administrator, correct?
Correct.
Those are all the questions I have.
Thank you. All right. Go ahead and step down and stay in the either in the hallway or the witness room that we had you in for now, and then we'll give you further instructions. All right. Thank you.
Your Honor, I understand the court's ruling. I will have an opportunity to place on the record the nature of the
Correct.
objection. Thank you.
All right. So before you call your next witness, do we need to excuse the jury?
Probably so, Your Honor. I think that
All right. All right, folks. We're going to have some legal arguments, which I will have to rule on, and then we will proceed with the case.
Thank you. You may be seated.
All right, Mr. Hogan, you want to put the rest of your objection to, I guess, argument as to my sustaining the plaintiff's objection to trying to bring in Ms. Kovac's statement on the Axon video. Is that
Yes.
correct? That's what you want to address?
Yes, Judge, and I can clarify what we were doing in the nature of our argument for the record.
All right.
Judge, on cross-examination of Dr. Klinger, Mr. Beniozen asked her, Ms. Kovac, did Ms. Kovac tell Dr. Parker explicitly about a gun in a specific student? True. They began discussing the specific statements that Ms. Kovac made to Dr. Parker before the shooting. This same topic was revisited multiple times. At the transcript of 171-4, they indicate, question, okay, then we have a moment in time, as we talked about, where Kovac says, no gun in backpack, put something in pocket. Is that right? Is that true? And then there's acknowledgement that there was a discussion to that effect. That's the moment I'm talking about. These two areas of the transcript open the door to the line of inquiry about what specific statements Ms. Kovac made to Dr. Parker before the shooting. On to redirect, you were entitled to ask Dr. Klinger if in the course of reviewing this case, as well as the materials, including the body-worn camera materials, whether she knew specifically what statements Ms. Kovac made to Dr. Parker before the shooting. I understand that this was a subject of argument and litigation before this moment of time in this proceeding, Judge, but counsel opened the door to this line of inquiry by asking details about the specific questions that Ms. Kovac presented to Dr. Parker and the information that was relayed to her, her specific statements. What would happen is Dr. Klinger would take the stand. She was asked whether or not she reviewed the body-worn camera to prepare for this case. She acknowledged that yes. She also acknowledged and confirmed that she did not recall specifically what statements Ms. Kovac stated. Then she said, yes, if I were presented with this body-worn camera, which I reviewed to form the basis of my opinion and testified here today in court, it would refresh my recollection. At that juncture, Judge, we were entitled to refresh Dr. Klinger's recollection to see if she could independently recall what it was that Ms. Kovac said to Dr. Parker before the shooting. As a matter of law, you can refresh a witness's recollection with anything, provided that opposing counsel can review it. We were not going to introduce that video through this witness. We were not refreshing her through another recollection through another witness's testimony. We were just asking her to review the materials she has reviewed the entire time and recall whether or not she remembered what Ms. Kovac said. I acknowledge this would not have been fair game but for Mr. Beniozen's line of inquiry and cross-examination. To bar it now at this juncture would prejudice our case, Judge. I'd ask the court, with respect, to please revisit its ruling. I'd ask for an opportunity to recall Ms. Kovac and introduce this line of questioning.
Response?
Judge, what I hear is that we want to refresh a person's memory of a conversation they were never a part of.
And that's inadmissible.
Correct. And so procedurally, you can't even refreshing of a memory implies that she had a memory of something from that period of time. This isn't a conversation that Dr. Klinger was involved in, nor is the material that they're wishing to proffer as the refreshing information of that time frame. I was very specific in the questioning of during that time, during the conversation, before the shooting. What they want to show is what Your Honor's already ruled is inadmissible for the reasons Your Honor's previously stated, which is something that happened at 2:20 in the afternoon. We're not talking about body camera footage that was capturing conversations with Ms. Kovac and Dr. Parker at noon, or at 1 o'clock, or at 1:30. This is after the fact, and we're going to try and say to this witness, it's going to refresh your memory of something that you never even participated in.
Well, and that you can't testify to, which
Correct.
I've already ruled. So, yeah, I'm not going to allow you to do it that way. I also find that it's more prejudicial than probative at this time in the case. So I'm sustaining the objection.
Thank you, Judge.
All right. All right. Do you have another witness to call?
No, Your Honor, you rest.
Defense is resting.
No, Your Honor, we would seek to introduce 2 videos. No witness is required to establish a foundation for this. I'd ask to hear argument on this.
Okay, well, I mean, we've seen the video. I mean, if you want to make a new argument that you can, all right, say it once again, stipulation for purposes of this argument only that the proper foundation is laid, continuing objection for all the reasons already stated by plaintiff. What is your hope, intent, or argument that could be played with the proper foundation?
It's twofold, Judge. If I could pass this over to
Where we are at this trial now.
Yes.
Okay,
Your
all right.
Honor. If I may share this with the opposing counsel, I prepared a bench brief on this topic. Deputy, please pass it to the judge. Thank you.
Okay, and while we're at it, can we let the witness go based on my ruling?
Yes,
All right, you can release the doctor.
Judge, I'll give you an opportunity to review that.
All right.
Please let me know when you'd like me to proceed.
All right, so your objection wasn't to relevance, because they're clearly relevant. I mean, I don't see any argument as to that, but the issue then becomes, is it hearsay or not? Did you want to respond to that?
The question of whether or not the statement.
Well, I mean, I guess I'll hear you if you don't think they're relevant, but, I mean, I think they've laid a groundwork for that at this point. So then, to me, their other objection, unless I'm reading this wrong, is that it's not hearsay.
The point that I would make on relevance, Judge, is that they're arguing that the state of mind of one person is relevant to determine the state of mind of another person, to then determine a fact at issue. That is, Ms. Kovac's state of mind is relevant to then determine what Dr. Parker's state of mind was, to then determine whether or not the threat was credible. And I think that is a stretch of the relevance argument. And if anything, it is a 403 issue just based on that. We're not talking about hearsay. Then we get into the world of hearsay, and they're asserting that they're not offering for the truth of the matter asserted, at least within the written brief. But then the question is, what is it then being proffered to provide? If you're not offering it for the truth of the matter that Ms. Kovac didn't think it was a real gun, which is what they're offering it for, you can't, then why then is it relevant to her state of mind? You can't have it both ways. The only way that it becomes relevant, arguably, is that if it's offered for the truth of the matter asserted. And if it's offered for the truth of the matter asserted, it is then impermissible hearsay that doesn't fall under any of the exceptions within the rule, specifically 8033, which is what we talked about before, because she is talking about not a then existing state of mind, not an existing state of mind at the time. She's talking about we thought. And so again, if this was a recording at 12:30 or 1 o'clock, we'd be talking about different things. This is a recording after the fact, after the shooting. And effectively, at this point in time, it's intended to impeach the testimony of a witness that's already testified. And they can say they don't want, that's not what the purpose is, all they want. But when we're offering something that was not confronted to with the witness, and now trying to say, well, we're offering it now to show what she really thought, different than what she said on the witness stand, it is implicitly, if not explicitly, being offered to impeach the credibility of the witness. And they're right. And the relevance analysis is grounded upon this idea that when she says we thought, first, who's we? Okay, that's a determination to make in terms of relevance. Second, we thought when? We thought at 12, we thought at 12:30, we thought at 1:30. These are all the reasons why hearsay statements are generally excluded, because you don't have the opportunity to question the witness or cross-examine the witness on what they truly meant in the circumstance. And so here, what we have is, whether or not it's an authentic video doesn't change that it's hearsay.
I agree with that. I agree with you on that.
Hearsay statement, and it is inadmissible unless they can offer another reason. They're now foregoing the truth of the matter asserted and saying it's offered to prove, not for the truth of the matter asserted, it's offered to prove her state of mind. And then the question becomes, why is Ms. Kovac's state of mind at 2:18 p.m. on January 6th have any pertinent issue in this case?
But isn't it now relevant based on the doctor's testimony today, based on everything that she has now reviewed, observed, and your cross-examination of her?
Your Honor, how so? I don't see that, because the analysis, as we walked through with Dr. Klinger, was what was the foreseeability of this throughout the day, up until the time of the shooting. And she wants to talk, she didn't even get into this question of foreseeability of it now, right? You allowed her to say it's unprecedented, which we objected to. And so for her now to say, for her to take a statement from 2:18 p.m. and proffer, witness is gone now, so we can't say that it's pertinent to her opinions because no one's asked her about it. Witness is gone. To say, well, this changes the expert's analysis, how? How does that change the expert's analysis when we weren't, the goal of the expert analysis was supposed to be what was going on during the time in which it happened? You couldn't hear it. The only way in which, if they want to get this testimony in, which is, did you think it was a toy gun? Did you, Ms. Kovac, think it was a toy gun? So you call Ms. Kovac. And then if you say, did you think it was a toy gun? And if they said, who else thought it was a toy gun with you? I think if we objected, Your Honor would sustain it, because that would be asking for speculative testimony. Who else thought it, including you? If the statement is, did you tell Dr. Parker it was a toy gun? That could be relevant, but that's not in the recordings either. The question in the recording isn't what did you tell her. The question, the colloquy in the recording is we thought. And so if they wanted to call Ms. Kovac, which is how I implied your rulings from last week, which is, I'm not saying you can't do it at all, but you got to put on the right information to lay the foundation. If they called Ms. Kovac and say, did you tell her it was a toy gun? Fair game. Have Ms. Kovac say, did you tell her or not it was a toy gun? But that's not what they're offering it for. I mean, that's not how they're offering to do it. Today. They're trying to say, this statement about we thought, you can imply, we've had this argument, right? We had this argument last week. We can imply that the we is her and somebody else, and we can imply from that there's a statement that was made, again, hearsay statement, that was made to Dr. Parker earlier in time, none of which has foundation in the actual recording.
All right, anything else you want to argue other than what's in this bench brief?
Yes, Judge, I need to address some points raised by counsel that are worth mentioning. First and foremost, we're not offering this for impeachment. We're offering this as substantive evidence. There's no impeachment issue here. How are we offering this as substantive evidence? We're offering this because these recordings, they're separate. They have similar statements, but they're separate and discrete. The first one, Exhibit 57A8 states, Kovac is speaking to a law enforcement officer and represents. He had something in his pocket. I said, keep it in your eye, you know, and I went and I told my AP that, you know, this and this, and we were just watching him. And if anything, we thought it was just a toy. This is relevant because it shows Kovac's state of mind at the time, both at the time that she makes the statement, as well as at the time the jury can infer at the time these incidents were occurring. Where do I get that? Counsel's flagged a timing issue. He says, what does it matter what, number one, why does Kovac's state of mind matter at all, period? Number two, okay, assuming that it does have some relevance, why does her state of mind matter after the shooting versus during the events preceding it? The response is, number one, Ms. Kovac's testimony regarding her, or evidence establishing her state of mind, is relevant, given, as the court has said, Dr. Klinger has testified that the jury, when they're assessing whether or not it was an objectively reasonable administrator, would have responded, whether, when, and how to respond to the information she received. One of the salient factors is the subjective assessments of the reporting parties, the subjective assessments of the first-line responders. That includes teachers, staff, guidance counselors, etc. What is in their head and their individual assessment, exercising their independent judgment and discretion as to whether or not this reported threat is indeed a credible threat, is indeed an actual weapon, matters. She's explained that. The jury has heard that evidence. It's unchallenged. It's in evidence now. That's relevant. In addition, the timing issue. Why would her state of mind at the time of talking to the law enforcement officer matter? Well, that matters because under Canopy, Judge, which is cited in the brief, it's well established that someone's state of mind or statements reflecting their state of mind at the time of the utterance of the statement is probative of their state of mind at the time of the incident or the events leading up to it. They use this all the time, where statements that people make after the fact of a crime, for example, or any other incident, can be probative of their mental state at the time of the incident. Circumstantial evidence is used all the time to infer somebody's intent and knowledge and state of mind. And the other thing worth highlighting here, judges, I'm not doing the then existing mental state. Then existing mental state is a discrete exception to the hearsay requirement. That's 803.3, I believe, if I'm not mistaken. I'm saying this is a straight up non-hearsay purpose that is established in the treatise that I cite. If you're offering a statement just to show that for the sole purpose of establishing the state of mind of the declarant, that's not hearsay. That is well settled in the case law. It is discrete from the then existing mental state. So I think this is probative not just of her mental state at the time that she's talking to law enforcement. The jury can look at that and rely on it, assess her credibility and demeanor when they watch the video and say, look, I think that as substantive evidence, this lady actually thought that this was a toy gun. And in fact, she thought it not just then, but also at the time she was conducting this investigation.
Yeah, but then doesn't it become hearsay and you're contradicting your own argument, right? Because if you want to argue it substantively and we don't give the limiting instruction, then you are saying it's for the truth of the matter.
But no, it's establishing that this is her mental state. This is what she believed at the time that she's making this statement. The jury can draw their own inferences. If you're worried that they will establish that, okay, in fact, this is truly, this was believed that this was a truly an actual weapon, we can give them a limiting instruction. These things can be cured. The remedy is not straight up exclusion. I'd also note, Judge, that although we've addressed this kind of together, there are separate arguments that apply to the other video. The other video I'm offering to establish a notice, and I can address that separately or now, if you would prefer.
You can put it on the record.
What I put on the record with respect to that clip, Judge, is you can see that in that one. Ms. Kovacs states that she told Dr. Parker that she believed that this was if anything, this was a toy gun. Excuse me, she also, for video exhibit 57A10, let me clarify. She is speaking to the law enforcement officer. She says that they checked his bag like we thought, and she didn't say anything back to me like he moved something back from his pocket, like, I don't know. And then she emphasizes that, again, it's a 6-year-old. That is different. That is clear evidence of her state of mind at the time of making this statement. That is something that is consistent with the other evidence in this case, that no one here could have fathomed that a 6-year-old child would have perpetrated this offense. That's something that a jury should hear. That is something that, given an appropriate cautionary instruction, you can say, yes, I'm just considering this for the purpose of establishing her mental state at the time of making this statement. All the other statements leading up to it, although they could be offered, they could run afoul of the hearsay rule, Judge, I'll be candid. The case law also establishes that statements that otherwise would constitute inadmissible hearsay can be considered solely for context. If we're just looking at that statement, again, it's a 6-year-old. If you watch the video, Judge, Amy Kovacs is saying this after Dr. Parker. This whole time up to this point, she's been talking to Corporal Blythe individually, recounting the incident. This is the time where Dr. Parker comes out of the office. What do you see on the camera? Amy Kovacs peers around the corner, sees Dr. Parker, and her demeanor palpably changes. You can see it. She becomes withdrawn, and then she starts emphasizing and mitigating and trying to distance herself from wrongdoing. And that can be inferred fairly from the evidence by the jury. And how do we know that? Because she says, well, we searched the bag like we thought, and then she looks to Dr. Parker, she looks to Laura Harris, who was present there, and looks to them for assent, and they nod assent. And then she says, she didn't say anything back to me like he moved something back from his pocket, like, I don't know. That is all legitimate evidence for the jury to consider. It is her demeanor, it is the way that she's responding to law enforcement, all of that combined with their final statement. Again, it's a 6-year-old. That is something that a jury should hear. It does not run afoul of the hearsay prohibition. I'd ask that it be introduced.
I'm going to sustain the objections for the reasons previously stated. It is more prejudicial than probative at this time.
Thank you.
All right. Are you, any other witnesses?
We rest, Your Honor. We have some exhibits that we need to make sure that we have the correct ones. If we can do that after, I just want to make sure that's okay with the court.
Defense rests. All right. Is there going to be any rebuttal evidence? No rebuttal evidence. All right, so you're asking for a few minutes to organize the exhibits?
Yes, Your Honor.
All right, and then when you are ready, let my deputy know, and then I need a conference on another matter in my chambers. All right. Thank you very much. We'll be in a brief recess. Let Hop know when you're ready.
Conference
We'll
with
go from
us
there.
in your chambers, correct?
What's that?
Conference with us in your
Yeah,
chambers?
with both sides in my
Understood.
chambers after they're ready with their exhibits.
Yes, sir.
Okay, thank you very much.
And Your Honor, I might be able to get that in motion and then come sooner.
Okay.
Okay.
Well, stands in recess. Nine jurors in the box.
Ms. Douglas, does the defense have any more evidence?
No, Your Honor, the defense rests.
All right. Mr. Beniazin, any rebuttal evidence?
No, Your Honor.
All right, thank you very much. All right, ladies and gentlemen of the jury, this concludes the evidentiary portions of the trial. The attorneys and I are going to work on the jury instructions for the rest of the afternoon. There's no need for you to stay for that. So I'm going to release you and remind you that tomorrow is Election Day and encourage everyone here and out there to vote. I do need to give you 2 specific instructions about your recess and tomorrow. We are recessing now for our evening break. I ask that you be back in the jury room at 11 a.m. On Wednesday. All right? During this recess, you are not to begin the discussion of any of the aspects of this case. Upon your return, you are requested to go immediately to your jury check-in room in the main building and do not hang around the halls. You are not to engage in any conversation with any of the parties, the witnesses, the attorneys, or any of the spectators, including the media. You are not to go to the scene of the case or undertake any independent investigation. I will have specific instructions for you on that in a moment. No one should approach you and discuss this matter, and you should not remain within the hearing distance of anyone discussing any aspect of this case. Of course, that includes viewing any newspapers or television or listening to the radio. Only election coverage for you folks tomorrow. You must also leave your notepads and any notes you have taken with my sheriff. If you are approached by anyone concerning your jury service during the course of this trial, you should make that fact known to my sheriff, 11 a.m. on Wednesday. Additionally, ladies and gentlemen, I have previously advised you, and I did just again, that you are not to go to the scene of this case. Rich Neck Elementary is a polling location. If any member of the jury votes at that polling place, you are instructed not to go anywhere other than the location of the polling boxes. Do not undertake any action to view the scene or investigate for yourselves any location described during the trial of this case. All right. Thank you very much. Vote, and I will see you Wednesday at 11 o'clock.
Okay.
All right. You may be seated. Any motions on behalf of the defense?
Yes, Your Honor, Judge, the defense would have a renewed motion to strike. I'll keep this brief. First of all, I would expressly incorporate all prior arguments I've raised during the initial motion to strike. I would also expressly incorporate by reference all prior arguments I raised on the related motion for summary judgment, motion and motion for a special plea of sovereign immunity, as well as the related briefs and oral argument on the same. At this stage, Judge, I just want to highlight and emphasize a few pieces of evidence that can affect the court's analysis at this stage. First and foremost is we talked about evidence of duty and breach of duty. And here, where there is the sole theory is that there's an assumed duty to exercise reasonable care for another's protection, to protect them from third-party harm. That duty, that undertaking has got to be expressed. You've hit this a million times. The court is well familiar with the case law on that point. What is different is that now we have the plaintiff's answers to requests for admission that were admitted. They are unchallenged. They are dispositive and established conclusively in this case. One of the answers in response to a request for admission was that was no to the question whether or not Dr. Parker ever made an express promise or agreement to protect Ms. Werner, either on the day of the incident, on January 6, 2023, or before. That should be dispositive, Judge, under the case law. That should be dispositive because under Terry versus Irish Fleet, there must be an expressly communicated, an express communication of a specifically described undertaking to protect another from third-party criminal harm. That is completely absent in this case, and now we have Ms. Werner's explicit admission on that point. And not only admission, but one that is binding and conclusive as a matter of law. In addition, Judge, I want to highlight that when it comes to establishing the 3 potential prongs under the restatement, in addition to duty, breach, proximate cause, etc., they need to establish one of 3 of these possible avenues for relief under restatement. Second, of course, section 324A. And the first is either Dr. Parker's breach increase the risk of harm or induce reliance by the plaintiff to her detriment, or alternatively, that Dr. Parker assumed a duty that a third party owed Ms. Werner. On the final point, as before, I just want to emphasize that portion of this doctrine, that particular prong has no application in this case. That is, if you look at the restatement, section 324 in the comments, it explains that that typically applies where there's an express contract or agreement to undertake obligations by some entity. And usually, almost all those situations are it's like a security force, private security force saying, look, this business has a duty to protect its patrons. We are going to outsource this responsibility to you by contract. Sign on the dotted line. You agree to provide these services for us that we are obligated to do. And then you can be on the hook that way. That's completely absent in this case. I've heard no evidence to establish that that theory, that particular prong, has any application here. In addition, evidence of reliance. We've talked about this previously, but it bears emphasis that although in the restatement it only uses the language reliance, the case law interpreting it has added specific requirements. The first is Age versus Church of God in Christ, which explicitly says the reliance must be justifiable. And then Terry versus Irish Fleet, as well as Didado versus Strayer and others, have repeatedly said that not only must it be justifiable, but it must also be detrimental. And that matters here, Judge, because although there is not a significant amount of assumption of duty case law interpreting that language in that specific context, there's ample authority applying those terms in other contexts of the law. This is something that transcends the just tort doctrine. It applies in equitable estoppel, it applies in fraud cases. Lots of cases have talked about what is reasonable reliance, what is justifiable reliance, what is detrimental reliance. And what it boils down to, Judge, is that, look, in this case, first and foremost, there can be no reliance as a matter of law, where the party who's asserting reliance, saying that I relied on somebody's express assurances that they're going to protect me, there cannot be any reasonable reliance as a matter of law where that person either knows the true facts or has equivalent access to obtain those true facts. To make that concrete, a good example was illustrated in the Nolde case. Nolde was the hand-waving case that's cited in Terry. There's a motorist driving, go ahead across the street. They get hit by an oncoming vehicle. There was no there's no assumption of an undertaking there. There was no reasonable reliance in that case because they examined, look, what did the pedestrian know at the time that they were crossing the street? And they said, well, they were in a position where they could see the oncoming traffic. Not only could they see the oncoming traffic in the imminent danger, they also could see and observe that the motorist himself was not in a position to ascertain or assure anybody's safety because they couldn't see oncoming traffic. So in that circumstance, it would be unreasonable as a matter of law to say, I'm on notice, I can see there's a car coming, there's a guy over here that I can see who can't see what's going on, this guy's saying, go ahead. It would be unreasonable as a matter of law for me to proceed, knowing what I know. That has some application in this case, Judge, because the fair inference for the evidence is that, taken as true, with all inferences flowing to the plaintiff, there are cases that there were repeated reports to Dr. Parker that there's a firearm, there's a firearm, there's a firearm, we need to act now. That's their theory, that's their case. And if that's the case, the people who are asserting that, who are providing these reports, were the first responders. They were the people who were on scene, they were closest to the action, they heard the initial reports. Ms. Amy Kovac heard the reports from two students saying that there might be a gun in this child's backpack. There was Ms. Jennifer West, who interviewed R about his statements and his interaction with JT, who was a student they all suspected might have a firearm, now on his person at that stage. And all of these people, including West, Kovac, Sims, Rawls, all these folks, they had firsthand knowledge about what was going on. And none of these people could have relied on any assurances made by Dr. Parker as a matter of law. There were no assurances made. We've heard that from the RFAs. But even if that were the case, there couldn't be reasonable reliance as a matter of law, given what these parties knew, given what they've come into court and said we knew at the time. In addition, Judge, related to that, there is a thread of case law that establishes reliance may also be unreasonable as a matter of law where somebody undertakes an investigation to ascertain the true facts. I will acknowledge that that's usually confined to the context of usually it's property transactions where someone's a buyer, a sophisticated buyer, and if they undertake any investigation to ascertain any defects in the property or title, etc., then it will be imputed to them, hey, if you have followed through on that investigation, you would have found out, so you can't rely on the seller's assurances. So I'll acknowledge with respect to that piece, Judge, that's a little bit more tenuous, but overall, the principle that you cannot have reasonable reliance as a matter of law where you know the true facts, have the same access to the person you're relying on, is no good. The other piece, Judge, is that when it comes to detrimental reliance, that's something that comes from Terry and Didato. You've heard about this repeatedly, but it's important here because even in the restatement, they talk about how detrimental reliance is kind of the crux of the assumption of duty doctrine. That's kind of where it all started. Even outside of the third-party criminal harm context, that's usually the types of cases you get. If somebody makes some sort of representation, then there's reliance to your detriment based on that. If you look at the restatement and it talks about what that means, what that looks like, you'd have to establish at least a couple things. The first is that Dr. Parker's representations, which I again do not concede, they did not exist here, but to the extent that there were representations, they induced the plaintiff to rely on them and induced her to forego taking safety precautions that she otherwise would have done for her own safety. And we've heard from Ms. Werner, and she's testified, and at no point did she testify or suggest or imply that, but for the information she received from Dr. Parker or anybody else, she would have called 911, isolated the student, detained him, searched the student, taken any other reasonable safety precautions that Dr. Klinger has talked about. She's not testified to that. There is a gap in the evidence. There's a gap in the evidence that they were required to establish, and the jury can't fill it in. They can't fill it in through speculation. And given that circumstance, Judge, you'd have to strike the case. You'd have to strike that case because there is no evidence whatsoever of any detrimental reliance. In addition, Judge, the third alternative avenue of relief here is they can try to establish that Dr. Parker's, again, to the extent she made any representations, that those increased the risk of harm. That's a more nebulous standard, Judge. There's not a lot of case law talking about that explicitly. But what you see in the comments is that basically someone made a promise or agreement, which again, no evidence of that whatsoever, but someone makes a promise or agreement, and then because of that promise or agreement, somebody ends up worse off. Again, it's more nebulous, but I just want to highlight and caution for the court that that increase the risk standard does not substitute or supplant proximate cause. Proximate cause is still always going to be at issue. I just want the court to be aware of that. When it comes to that problem, though, I would contend, Judge, that there's been no evidence whatsoever establishing the extent to which, if any, Dr. Parker's representations or assurances or conduct or statements in any way increase the risk of harm in this case. By all accounts, and it sounds like this was a unprecedented, unforeseeable event. No one, including all of the witnesses that came in here and were paraded into court, identified Dr. Parker, accused her of what we're here in court for today. All of those people themselves acknowledged that this was unforeseeable. And given that circumstance, you cannot establish that there was an increased risk of harm based on anything she did or did not do. Lastly, Judge, I'll just hit home here when it comes to gross negligence. I know you've heard me say it, I'll say it again. This is an indifferent standard, not an inadvertence or carelessness standard. And that's crucial here, Judge, because there's been no evidence of actual indifference to repeated or reports from these parties that there might be a threat on campus. You've heard the opposite. Perhaps initially you've heard from some of the witnesses testifying. For example, Ms. Werner testified that when she initially came into Dr. Parker's office and reported some misbehavior in the cafeteria, there was no reference at this stage of a firearm. This was a separate incident. There was no knowledge of that threat at that stage. But her testimony was that Dr. Parker did not look up, did not respond. Amy Kovac also testified similarly. However, even Amy Kovac testified that while she was in the room and witnessed that exchange, she said Dr. Parker, after Ms. Werner was on her way out the door, Dr. Parker turns to Kovac and directs her, let Ms. Werner know that if she's uncomfortable, if there's any continued misbehavior by that student, she has authority to pick up the phone and call that student's parent to pick them up early. And that had been their practice up to that point. Whenever there's been misconduct or misbehavior by that student, typically they would call the parents or they would call for assistance to isolate, take care of that kid, or get them back to home with their parents. That wasn't done in this case. That's important, Judge, because that shows that there's arguably at least the exercise of some degree of care. There's ongoing responses to each of these reports. There's also communication and action by Dr. Parker in response. And this is highlighted by Amy Kovac, of all people, her testimony was that at one stage when she came in, she initially maintained that all by herself, she decided to search this backpack. She got the idea all by herself. She went in there, put on her detective hat, opened up the backpack, and searches for a firearm, doesn't find anything. But she also couldn't help herself in her testimony. She acknowledged that when she spoke to Dr. Parker, she said, well, yeah, I told her I intended to go and search that backpack. And Ms. Toscano asked her, well, how did she respond? And she said, Dr. Parker nodded. She nodded her assent. And the question that was posed to Amy Kovac at that stage was, did you receive any response or, quote, direction or were directed? And so it's in that context that she was testifying and explaining that I put the assistant principal on notice that I intended to search this backpack because of a potential threat that it might contain a weapon. And in response, she nodded. And so arguably that constitutes assent. That is not just someone independently without the administrator's knowledge going in and undertaking an investigation. That is essentially seeking authorization to do so. And if that's the case, that's the exercise that is the exercise of at least some degree of care. It's not indifference. So, Judge, for those bases, on all those grounds and those stated previously, I ask the court respectfully to strike the charge with prejudice.
Ms. Piniella?
Your Honor, this argument is duplicative, I think, of what was heard at halftime. In fact, even the evidentiary backing of it is relying upon the plaintiff's case in chief rather than the defendant's case in chief. And so for the reasons that we previously argued on the motion to strike at halftime, I'd ask that we be able to expressly assume those so I don't have to repeat myself.
All right, those will be incorporated.
And then, obviously, we disagree on the state of the law, so I just pointed this out on the issue of Burns v. Gagnon and express duties. There is nothing in the Burns v. Gagnon case that reflects a statement from the assistant principal, Burns, to the student Gagnon, and yet the court still found the assumed duty of care was appropriate and that it was a finding that the jury needed to make, both as to what was assumed and whether it was breached. And this position that these RFAs are somehow dispositive of some material issue is directly rebutted by the Burns case, and then again in the Terry versus Irish Fleet case, to the extent it discusses it, talks about express undertakings, recognizing it's not from person A to person B. That's not the legal requirement, even in the case of Terry versus Irish Fleet, which we think is inapplicable because of the third-party crime context that we discussed previously. And so for the same reasons we argued previously, we've met our burden. Certainly a reasonable jury can conclude that both an assumed duty was met either three prongs of 324A of the restatement, which was incorporated by Burns v. Gagnon, and then ultimately when we get to the question of the breach of the duty and whether that breach amounted to gross negligence, our view is any indifference, that is, the foreseeability is for the jury to decide, but even their expert conceded foreseeability of that threat, that any action or inaction that was taken by Dr. Parker in and of itself was demonstrative of indifference, but that's ultimately a jury issue. And we get to this issue of cumulative conduct, which is referenced in the Chapman versus City of Virginia Beach case, which we also think meets the burden as it relates to gross negligence. And so for the reasons we stated previously, for these reasons, we think the burden has been met appropriately at this stage to let the jury and the finders of fact decide this case.
Judge, I made 2 quick points to address novel issues raised. The first is, I want to clarify the nature of my argument. My argument with respect to an express undertaking communicated by Dr. Parker to anybody, that is not, the nature of my argument is not that there's been no evidence that Dr. Parker directly conveyed a message to the plaintiff. That is important, but more important than that is that there was no express communication whatsoever of a specifically described undertaking to protect anyone, much less the plaintiff. All of this is based on tacit assurances. All of this is based on implied conduct. All of this is based on implication. That has been categorically rejected by the court in Terry versus Irish Fleet. So I acknowledge that in Burns, Judge, this is worth paying attention to. In Burns, they did have a statement from the principal. It was not to the plaintiff, but it was to the student who came to the principal's office and said, look, this student at the school, there's going to be a fight later today with this student. And in response, unlike in this case, in this response, the assistant principal there expressly said, I will look into it. I'm going to check into this. That was the legal hook that the appellate court seized upon and said, look, that is something that creates a jury issue. That's something where they can figure out, hey, by saying I'm going to look into that and then failing to follow through on that representation, that's what gets you over the finish line. That's what gets you in front of a jury. That's what gets you an express undertaking, potentially. Here, there's been no response from Dr. Parker. They've never said that she's ever said or explicitly said, yes, I'm going to get right on that. Yes, I will take that up. Yes, I'm going to look into this. It has all just been implied through voluntary comment.
All right, for the reasons previously stated, the court finds that the plaintiff has met their burden at this time, and the matter shall go to a jury. All right, we're ready to begin with jury instructions.
Yes, Your Honor. How would you like to begin?
Great question, Mr. Benioff. All right, so the way that I had it organized was I have the stack of agreed. So we've all got that stack, correct?
Yes, sir.
All right, and obviously we'll put together a final stack for everyone to double check, but I've got that stack. All right, next, what I've done is I've gone with defendants' offered instructions that are lettered, and then I've put your matching or similar to those in order as well, and we can discuss those at the same time. And if I've missed anything, then you can correct me and say, no, we need to discuss this. If that makes sense, Mr. Benioff.
Yes, Judge.
All right. All right, so let's go with defendants offered instruction A. All right, offered and then objected to with, it looks like 2 different versions offered, Mr. Benioff, if I'm correct.
So we have, I look at them as the finding instruction, and then there's the, I forget how the Virginia model talks about it, but the one that I think competes is your verdict must be based on the facts as you find them. Is that what you're looking at the
Correct.
top?
I've got 2 versions from your side. No, I don't. I'm sorry. So I have one that starts, your verdict must be based on the facts, right? As you find them, etc. And then I also had one that was very similar. You shall find your verdict for the plaintiff if she is proved. Does that go to a different?
Those are 2 different model instructions. I don't always think that they're both necessary, but we've proffered both.
Okay, but that would go in the same place with this one, correct? Do you agree with that?
It would go, I think your verdict must be based on the facts as you find them is competing with their instruction A.
Right?
Yeah.
Okay. All right. So state your objections to defendant's instruction A.
Yes, Judge. I think to start, it's voluminous and confusing. Second, I think that when we get into what we must prove, in other words, there's a whole paragraph that's not contained in the VMJI, that's the second paragraph, that talks about what must be proven. A, we don't agree with that recitation of the law, which is also discussed as elsewhere in other instructions. But B, this is simply a finding instruction. That's why the VMJI has it, which is to say these are the issues for you to decide. It's not to actually give them legal instruction on how to apply the law to those issues. It's just to say these are the issues. And then the instructions later will tell them how to decide the issue at bar. And so that entire second paragraph is impermissible in our view in a finding instruction, and it doesn't recite the law as it is applicable here. So then we get to, accordingly, the issues in this case are as follows. And again, I think it breaks down the issues for the jury to decide in a much more complex and drawn out manner as compared to what they're going to decide. The issues here are, was she grossly negligent? And was that gross negligence a proximate cause of the damages? Now, I understand that there's going to be argument as to whether or not contributory negligence should go to the jury. We don't think that issue has been properly established to go to the jury, and so we would argue that at that stage. But there is, 7 prongs or little subsections here where the model gives us 2 or 3 to go off of.
All right.
Judge, to respond?
And I guess I just want to lay out, the Supreme Court has made it clear what our standards of review are for these instructions. One is it a correct statement of law? And then two, is there a scintilla of evidence to support that instruction? So I just wanted to couch that for everyone is how I'm framing each of these jury instructions. All right, go ahead.
Understood, Your Honor. First, with respect to the first point, I understand the counsel takes issue with the recitation of the law included in this instruction. This may be something where perhaps we can circle back to this when we discuss the other instructions that go into detail about. So I'll leave that to the court. But I would contend that this is an accurate rendition of the law as it stands today. And I would also take issue with counsel's characterization of this as a finding instruction. In the proposed instructions we compiled, Judge, I've seen many attorneys have two separate instructions where they're basically bookends to them. And at the front it says you need to follow the law and instructions as provided here. And then it will just lay out the potential issues. Later on, there will be a bookend instruction, which will be the actual finding instruction that will say, look, you must find for the plaintiff if X, Y, and Z are satisfied. We included both of those in our proposed instructions. They weren't duplicative. So I just want to draw that distinction. The other thing, Judge, is I do understand, I'm sensitive to the fact that especially in a case like this, you don't want to overburden the jury with complicated instructions. You don't want them to be too voluminous. You don't want them to be convoluted. But the nature of some of the case law here and some of the principles require some explanation. And without that additional explanation, and I will highlight it as we go along, they would be incomplete and misleading instructions. That is another principle that is well settled in the case law. To be an accurate statement of the law, it must also be complete. It must fairly cover all issues. That's the language they use. So just highlighting that from the outset, that at first blush, yes, this can seem like a lot, but this case does have multiple issues, and this is an accurate statement of the law. In terms of, I understand counsel arguing, I've seen this in many cases as well, when you frame the issues, you just say, look, it's two issues, right? Were they contributorily negligent, and was that the approximate cause of the plaintiff's injuries? I hear what they're saying. I understand that. There's an intuitive appeal to that. One problem with that, Judge, is I would contend that the proximate cause element is actually discrete from the three prongs under the restatement. The restatement has three avenues for relief that they need to establish. We talked about that. That's the reliance piece. That's the increasing the risk of harm piece. Or that's the assuming a duty owed by a third party to the plaintiff. If that is not encompassed in an instruction that just says you got to find someone contributorily negligent and that they were approximate cause, it omits the restatement prongs. And I say that, Judge, because it makes sense. You see in the Kellerman case, you see in lots of assumed duty cases where the court has emphasized proximate cause still exists in the assumed duty context, and but it's not the whole story. So, like for example, even if the evidence established that, for example, there was an express representation made and it led to an increase in the risk of harm. If an earthquake erupted, shook the school, and forced that child to accidentally discharge the firearm and it hit Abby Werner, of course that seems like an improbable circumstance, but that would mean that prong, that increasing the risk of the harm, was not the approximate cause of the injury. So all I'm saying, Judge, is that these are discrete elements. It would be incomplete just to say grossly negligent and approximate cause. You got to go into some detail. The other feature of this, Judge, is that by breaking it up element by element, I understand that can be cumbersome, but it also reminds the jury of what is required to be proven here. And a jury, unless they're properly instructed, may conflate. It's common sense, it's intuitive to a lawyer to say, yeah, when they're saying grossly negligent, I understand that's one element that goes to the breach, but it can also be used more broadly to mean all the whole shebang, all the elements. But here, that is not made clear in these instructions. So I would contend, Judge, if you elected to forego our more detailed instruction, then I would say at a minimum that we please include some additional language elsewhere in these instructions reminding the jury that these are the discrete elements that need to be established. You cannot have a verdict without them.
Did you have any other response?
Just the fact that we're arguing the entire case as it relates to instructions, as it relates to instruction A,
Right.
tells us that it's attempting to do much more than it's supposed to do. It's just supposed to say, this is what they have to prove, this is what they have to prove, and you have to decide those issues based upon the law and the facts as I instruct them to you. That's what the first sentence says. The law contained in all of these instructions. So you're telling them, I'm going to instruct you on all this stuff, but you don't have to cram it all into chapter 1.
But your proffer does not include the contrib, right?
It does not.
Which would be 3 and 4.
In other words, if Your Honor thinks that it's appropriate to instruct the jury on contrib, then so be it. We object to that issue. We don't think that there's been evidence, even a scintilla of evidence, to demonstrate that she acted contrary to what a reasonable person would do under the circumstance. But if Your Honor rejects that, we want to make sure that that's rejected in terms of the proffered version. And then if we have to make revision, we could make revision and add 3-4, and then it would effectively say on issues 1 and 2, the plaintiff has the burden. On issues 3 and 4, the defendant has the burden.
Right, so you don't actually have an objection to the actual law or issues that are cited in there. You just are more objecting to the presentation.
Both. I object to the law, but I certainly object to the presentation of it all contained in a single instruction, because the fact that it's cumbersome for us to have this argument on the law when it's all packed into one paragraph demonstrates that it's going to be very cumbersome for the jury to understand it, and then they're going to be forced to compare an abbreviated statement of the law in instruction A to a more explanatory statement in, let's say, hypothetical instruction H, and then we're going to get a question from the jury to say, well, which one do we follow, instruction A or instruction H?
Right. All right, so all right. Yeah, I think instruction A is cumbersome and includes too much, but I'm not saying that the case law is wrong. So I think we need to take, and I think almost all of these issues are brought up again in other places. So I'm not ruling it that it can't be brought up in other places if it's a correct statement of the law. I just think the model better sets forth from the beginning what the jury is going to be looking at. So I'm going to we're going to use the model instruction, whatever, after my ruling on the contrib into points 3 and 4, but I want it to look like model jury instruction 3.0 to start off. All right. All right, instruction B. All right, was there any competing offer from the plaintiff? I did not see one.
Correct, there's no competing instruction. We object with the applicability of the law in this context. Your Honor, the instruction reads, a legal duty to protect another from an intentional or criminal conduct by a third person. This is an issue that we've briefed, sort of in motions in limine in some part, but then also had raised an oral argument, which is this instruction is appropriate in contexts in which the conduct of the third, in this case JT, was intentional or criminal. And the issue here is JT, at age 6, is legally incapable of intentional or criminal conduct. He's incapable of it. Under Virginia law, and both the VMJI talking about contrib.
And this isn't a third-party case.
And this isn't a third-party case.
All right, so your argument is not applicable.
Not applicable.
Okay. All right, you have a response to that?
Yes, Judge, twofold. First, I would highlight and emphasize for the court that the case law, when it applies the assumed duty doctrine to the third-party criminal harm or intentional conduct context, that is the line of authority that requires the express undertaking. the reason why there's an express undertaking required is not the touchstone of that analysis, and the reason for requiring that it be expressed versus implied, like in other negligence contexts, is not because it's criminal, is not because it's intentional. It doesn't hinge on whether the criminal, the agent, the perpetrator of the act has agency to commit it or not, or can be held liable under the law. The crux is foreseeability. And usually intentional acts or criminal acts by a third party are not foreseeable as a matter of law. I would emphasize that this cuts against opposing counsel's argument. I would argue that the fact that under the law, a minor, 6-year-old child who cannot form criminal mens rea and also cannot be held liable, held negligent, that emphasizes and underscores the lack of foreseeability here. It's even more unforeseeable that this type of shooting would happen where this person can't even be held liable under the law. That is all the more reason why an express undertaking should be required. And I'm highlighting that, Judge, because that's really the aim behind trying to draw this distinction. If plaintiff can establish that this is outside the realm of third-party criminal harm or intentional conduct, they think they can circumvent this requirement that it should be an express undertaking. And then you get into the implied conduct territory. There's no basis for that in the law, Judge. There's no case law that's done that before. In fact, they've emphasized it turns on foreseeability, where stuff is unforeseeable as a matter of law generally. It's got to be express. And that's what this is getting at. Here, if there's any issue with the phrasing, characterizing this act as criminal or intentional, I can simply rephrase it to third-party harm, and it is a third-party case. The child is a non-party, but they use the term party not in the legal sense of someone who's party to a case or action or litigation, but an individual. And here, this is third-party harm. So we can just rephrase. I can eliminate references to criminal harm or intentional, but the doctrine and principles stand. It's got to be expressed.
Would you still object striking the first sentence so that it would just begin, the fact that a person realizes or should realize that action on her part is necessary for another's protection does not of itself impose upon her a duty to take such action? That's from the Restatement of Torts, right?
It is, but it's Restatement of Torts 314. And that's exactly what they're citing to. And if the duty, as Burns v. Gagnon talks about, is 324A, then we're effectively giving them an instruction of law that isn't the duty that's been alleged. And then what do they do with it? None of these cases, the Kellerman duty, not at issue. The Terry versus Irish Flea duty, not at issue. The AH versus Church and God in Christ, not at issue. Restatement second, torts 314, not at issue. What is at issue is the proffered instruction that we provided, that is almost verbatim to 324A. So in that case, if you want to look at that as a comparative here, but when we talk about these cases, my concern here is if the language that says, what we would have to do is make sure that that law is not contradictory to the law of 324A. And the cases, all of these cases that have analyzed these issues don't view them the same way. When you interpret the Restatement 314, you interpret Restatement 314, and Restatement 314 is in the context of controlling criminal intentional behavior. 324A is in a different portion of the Restatement that talks about assumed duties of care.
All right, so let's go to the third sentence then. A person may voluntarily assume a legal duty to protect another from third-party conduct, even though that duty does not otherwise exist. That's a correct statement of the law, too, correct?
It is a correct statement of the law. Again, when we talk about third-party conduct, that's where we have issue. So if it's stated, a person may voluntarily.
Right, I would just start, we would start with a person and then go through the end of that.
And I'm just comparing it to the 324A instruction that we have, just to make sure.
Which one? Oh, you didn't number yours.
I didn't. I apologize. That is 4 or 5 down. It starts with person who undertakes gratuitously.
Yeah, I had actually matched that up with instruction C, but I guess it's pretty close to what we're doing. All right.
So in other words, if Your Honor were to instruct a person on B, this is their version B, striking the word however, a person may voluntarily assume a legal duty to protect another from third-party conduct. The concern I have there is the proffer of 324A doesn't talk about third-party conduct. And 324A is what we've been guiding, what's been guiding this case from Burns v. Gagnon.
Right. All right, so are you in receipt of, once again, they didn't number or letter them, but it starts a person who undertakes gratuitously. All right, so basically, what is your objection to that restatement of Burns?
Well, Judge, if I may address your question this way, I think that our instruction B gets at a separate issue from our instruction C. You've seen our instruction C and you've aligned that as corresponding to their Burns instruction. We'll just call it the Burns instruction. That is because instruction B is getting at the broader idea. The jury needs to know that, in general, no one has an obligation, no one has a duty to exercise reasonable care to protect another from harm. They don't have an affirmative obligation to do that. That's what restatement section 314 is about. And why I think that's appropriate in this case, Judge, is because if you look at the cases, all the cases we relied on, including Burns, H. Terry, all those cases, they always, whenever they start explaining, okay, what is the assumed duty doctrine, what is that? They always start off by saying, in general, there is no obligation to protect another from third-party harm. That's always how they started off. And that's what this instruction is getting at. It's letting the jury know, hey, everyone, understand, ordinarily there's no duty to act affirmatively to protect another from third-party harm. And that's important in this case, because that is what's at issue here. Third-party harm by this child, JT. In terms of my problem with their instruction, it's not numbered, obviously, but their Burns instruction, I acknowledge that this pulls the language roughly from Burns. Burns, let me just emphasize, was also a third-party harm case. That was a criminal assault by a student. That was an assault. That was a tort. That was a crime. That was third-party harm, and that's exactly what it talked about in that case. There's the case law interpreting the restatement, and there's the restatement's language. Sometimes what the restatement says, Judge, does not say everything that the case law has expanded upon and elaborated and filled in the gaps. This is a skeletal outline of what the law is. So my objections to theirs are, number one, it's incomplete. But number two, if you look at our instruction C, we do a couple of things.
No, we haven't gotten there yet.
I'm sorry.
I don't think.
Well, but you had us, I may have misunderstood, Judge, but I understood you to ask me, what is the problem with their Burns instruction?
All right, go ahead.
One problem is subsection B. Subsection B is lifted straight from the restatement, and yes, it appears in Burns. I agree. But as I've argued, Judge, if you look at section 324A, which is what Burns parrots and adopts, that subsection only applies in those cases where it's like, it's a security company, they have a contract to fulfill somebody else's obligation to protect people. That's not, we've heard no evidence of that whatsoever. That subsection B has no application in this case. And rather, what will happen is that will create confusion. We talked about having voluminous instructions, stuff that might lead to confusion by the jury and mislead them. This is a prime example, because there is no evidence to support it. There's not even at least a scintilla of evidence to support it. And because of that, it should be struck. In addition, I know we haven't gotten to C, but we add and emphasize that the restatement is written with the baseline ordinary simple negligence in mind. That is why it talks about an exercise of a reasonable degree of care. That's how the language is couched in 324A. That's how it's applied in Burns as well. But none of those cases, they needed to have additional instructions clarifying that this is a gross negligence case. And so when we get to it at the appropriate time, I want to highlight that I've combined, not only have I done what Plaintiff's Counsel has done here, I have pulled in the language straight from Burns. I have eliminated subsection B, which has no application to this case, and I added a third paragraph emphasizing that mere simple negligence is insufficient as a matter of law to establish liability in this case. It has got to be gross. So that is why.
All right, I'm denying defendant's instruction B, granting plaintiff's competing instruction. With that, and then along with that, unless you wanted to be heard on defendant C, I was going to grant that in conjunction with yours.
Grant his C in conjunction with ours.
With yours, right. I think that they both state the law clearly. I do not believe they're competing. So that we would offer yours that competed with their B, which I'm striking, and I will allow them to offer C as a correct correct instruction and statement of the law.
Your Honor, the concern I have here is that their instruction C has prongs A and B in the paragraph, the top paragraph. Our instruction, which you've approved, has an A, B, C. Then when we get to similarly, on the next line, there's an A, they have an AB, where our instruction has an ABC. And then finally, this paragraph at the bottom that says, regardless of the above general principles, the court instructs the jury that in this particular case, merely proving that Dr. Ebony Parker failed to exercise reasonable care to perform an assumed duty to protect Ms. Werner from third-party criminal harm, there we are again with the word, is insufficient to impose liability. I don't think that that's a correct statement of the law in a vacuum. In other words, Your Honor will instruct them that it's a question of gross negligence, which is in the finding instruction, not simple negligence. So they know that it has to be gross. But when we get to this issue of cumulative conduct in the Chapman versus City of Virginia Beach case, instructing them that, it's just effectively you don't have to worry about the failed exercise of reasonable care isn't a correct statement of the law. It is that in conjunction with other things. And right. And then it goes on in the next sentence and talks about third-party criminal harm again, which again, this is not.
All right, you have a response?
Judge, I stand on the propriety of my original instructions, but I have a suggestion. Take it for what it's worth. If the court's inclined to grant their instruction, their Burns instruction, then perhaps we can just add the third paragraph of instruction C to emphasize that here this is a gross case. This is a gross negligence case. We can also tailor and eliminate the reference to criminal harm with the understanding that we're talking about third-party harm, and the same express undertaking doctrine would apply in that context.
All right, so you would strike the first two paragraphs, and then you would modify the third paragraph of your instruction C.
I think that would be fine. I'd also tell the court there's a separate instruction in our set somewhere in here that basically is not redundant, but is a refrain. It repeats the principle that this is a gross negligence case. So my main thing is if the court is inclined to reject ours, grant theirs, we need to have an instruction that is explicit, unequivocal, and clear to the jury. This is a gross negligence case.
Correct, and they're in agreement with that. So let me let you work on modifying that third paragraph.
I've just handed him, if it's helpful, a red line that I was working on over the weekend, which effectively says it's that top part of the 324A, which Your Honor's approved. And then it says, this is called an assumed duty of care, just to explain to the jury that's what that word is, assumed duty of care. And then the next line says, if you find that the defendant breached the standard with gross negligence, then you shall fine for the plaintiff. And if Your Honor permits the contrib, which we're objecting to, we could modify that to say, with gross negligence, you shall fine for the plaintiff unless the plaintiff was contributory negligent and their contributory negligence proximately caused the injury.
Okay. All right. So why don't I let you all work on that until we come back on Wednesday.
Yes, sir.
Right, and we're striking criminal. Correct. All right, that brings us to D. Plaintiff's D offered. Their plaintiff's position.
Yeah, Judge, I don't think any of this is necessary when we have 324A being instructed to the jury. We certainly object to this definition or description of express undertaking. I mean, criminal harm is littered throughout the instruction. And then this recitation of an implied undertaking is insufficient to create an assumed duty to protect another from criminal harm. That might be true, but again, this isn't about criminal harm. And so it's inapplicable in the context of this case.
All right. Your argument?
Judge, it's a red herring to distinguish criminal harm versus intentional versus just third-party harm. These same principles, the express undertaking requirement, has been implemented in all these cases, regardless of whether it's criminal or intentional or otherwise. The point is that where the harm is perpetrated by a third party, an individual who's not a party to the litigation, it would be generally be unforeseeable as a matter of law, except if there's a special relationship or an assumed duty. And we're talking about assumed duty here. And so, again, I want to highlight, in the court, this should raise red flags for the court, because what is happening is counsel is trying to, well, I would argue that this is a tactic to take us outside of the realm of the doctrine requiring an express undertaking by drawing some distinction between, well, this isn't really criminal harm, this isn't really intentional harm, therefore the undertaking need not be expressed, it can just be implied, just like in the motorist cases. Just wave somebody over through implied conduct, there you got your assumed undertaking. That's not how this works. The case law is clear. If you look at A.H. Church of God in Christ, if you look at Terry, you look at all these cases, you look at Kellerman, you look at all these cases, they always say that an express undertaking is required. It's what we've been arguing about for months and months and months up to this case. You can't circumvent that requirement. This is not the way to do it. Drawing a distinction between criminal and intentional harm and saying this kid can't form mens rea, that's not the way to do it. They're going to do that. The way to argue that is what they argued previously, is that there is some latitude, there's some suggestion in the case law that conduct tantamount to express undertaking may be sufficient. And I would contend, Judge, that is taken from A.H. That is not the law. That did not alter the standard in Terry versus Irish Fleet. This standard remains unequivocal. It's got to be expressed. This instruction, all of the authorities cited right there for you, Judge. I'll just stand on that authority. Take a look at those cases. It'll tell you, it says these things. It says them verbatim. I didn't make this up. The implied undertaking is insufficient to create an assumed duty to protect another from third party. Just take out criminal. The same thing applies. The same thing applies. That is a red herring.
I would not
Your
take
position is it's inapplicable, correct?
Yeah, and I would not take his word on that being the law, Judge. The cornerstone of all of these cases is that somebody was murdered or sexually abused. Murdered or sexually abused by an adult. That's all of these cases. We do not have a murder or a sexual assault committed by an adult. It is a 6-year-old, as they've made patently clear. And I'm sorry that that's what the law is. But that's what the law is. It doesn't require, Burns v. Gagnon does not say what they wanted to say in this instruction. And that is why Burns v. Gagnon isn't listed once in their recitation of the law, of their citation of this instruction.
All right, I think it's more consistent with my prior ruling that this instruction is inapplicable to this case based on all the rulings we've made, both pre-trial and at trial. So I'm going to deny that objection. All right, E. I've got competing, I do have one competing with plaintiff, it looks like. This is the starts off, E, making a contractor gratuitous promise. Yours starts off, if you find the defendant undertook to render services.
Yeah, I don't think we need the if you find instruction. If
you don't need yours?
Correct. If
okay.
We included, as it sounds like from Your Honor's comments before, that 324A is going to have a sentence underneath that says, you know, you can only find gross negligence in what you've asked us to confer on. Which, if that's contained within that instruction, this instruction that is, if you find the defendant undertook, I don't think is necessary
Okay.
at that point.
And what about your E? Do you find that that's necessary then, if we clarifying in the other instruction?
That is a difficult question to answer, Judge, because what's happened with the elimination of the prior instruction, Judge, is a seismic shift in the landscape of this case. It basically eliminated the
Do you
express,
disagree it's inconsistent with my rulings up to this point?
striking the last instruction.
Right.
I believe my understanding of the court's prior rulings and the arguments that were raised on the motions for summary judgment was that the nature of the argument was that underage versus Church of God in Christ, conduct tantamount to an express undertaking may be sufficient. That is what was argued. That is what was litigated. That is different in kind from saying, look, stuff doesn't need to be expressed because this is not criminal harm or intentional harm. The argument was, hey, we've got a case H, Church of God in Christ, that embellished the Terry standard. And so it would still be proper, like the posture of this case would be, the jury would still need to determine, well, look, these interactions, each of these reporting parties like Kovac and Rawls, when they go in and talk to Dr. Parker, was it reasonable for them to construe her conduct, her demeanor, her statements in context? Would it be reasonable to construe that as her manifesting an intent to undertake a duty to protect them? That's completely in line with all the cases I've talked about, Judge. I would argue that striking this prior jury instruction D, based on counsel's new argument that this is not criminal conduct, that this is not intentional harm, is completely different. And it puts the case in a different posture because now it does make instruction E potentially less relevant. Instruction E is something that ties into the express undertaking doctrine, which we talked about, and that's still age, that's still Terry, that's also Burns. And Burns was also an express undertaking case, Judge. They seized on the fact that the principal literally said, I'm going to look into this. So there has to be some statement here, and I think this instruction is appropriate because not only that, a promise or agreement alone is insufficient, you actually have to have entry into actual performance of the undertaking. I will acknowledge that is a bit more of a stretch in the case law. Kinzer is a concurrence. I know that, Judge. But I think that part of why this instruction is important and meaningful is because instruction D was meaningful and important, and I don't think striking it for the reasons counsel has raised for the first time now in this proceeding and the recent proceedings is appropriate.
All right. I'm going to deny that it's not a correct statement of the law, and you're withdrawing your competing, correct, Mr. Biddinghausen? All right. All right. That brings us to F. It did not have anything directly competing.
It'd be hard. Judge, candidly, I don't know where to begin. I mean, I think it's...
For all the reasons previously stated.
Yes, Judge, thank you.
All right. All right, based on my prior rulings, you have anything else you want to say?
Judge, I would just suggest that the place to begin would be the restatement. The restatement contemplates reliance. It's expressed there. It's been adopted by the court, Burns and Terry and AH, and they built and expanded on the case law. They've articulated exactly what reliance means. Without this instruction, the jury's not going to know what reliance means. They're not going to have any idea.
All right, consistent with my prior rulings, I'm going to deny this instruction and noted objection. All right, that gets us to G.
Judge, I think it's inapplicable and unnecessary in light of the approved instruction on what an assumed duty of care is. Littered with the criminal language as well.
All right, anything else you want to say on that?
Judge, I stand on my prior arguments, and I would just emphasize that the path we are going down is basically making I would argue that this is like a caricature of the facts of the case. This is transforming this from a third-party harm case, which requires an express undertaking, to a novel, an ordinary run-of-the-mill negligence case. This is anything but that.
Based on an assumption of care. I mean, we agree on that, right?
Yes, Judge.
Okay. All right, for the previously cited reasons, I'm going to deny instruction G. All right, so H, defendants H.
Your Honor, I don't think it's necessary. The instruction that that Your Honor has already ruled on talks about increasing the risk of harm. This just says it again and then adds language as it relates to criminal conduct.
Yeah, and do you have any argument as to how that's applicable?
Judge, with respect to any reference to criminal conduct, again, that could be eliminated, converted to third-party harm. It would have the same impact. I thought the purpose of this instruction, Judge, is that, again, it is highlighting that when you look at the restatement, it talks about what the increased risk of harm prong is. You just need to remind the jury this is a gross negligence case. Provided, Judge, that we have an instruction that adequately informs the jury that gross negligence is the standard,
Which we will, yeah.
then I think I stand on my prior arguments.
I deny the same reasons previously stated, but also with the caveat that we are going to define grossly negligent. All right, do we have an I?
Yeah, there's a J.
Yeah, I think I did not get an I. Is that correct?
I
Okay.
don't have one in front of me, Judge.
All right, very good. So now we are on to J. All right, you're claiming this was not an issue in this case.
It was not, Judge. Dr. Ebony Parker never pled a constitutional right. And if she has not exercised the constitutional right, it's not appropriate to instruct the jury on the constitutional right.
Any response?
Judge, I understand the argument. I would just emphasize that my client has exercised her Fifth Amendment rights by not testifying. I understand that the dynamics are different in this little case. The case law talking about whether you can straight up refuse to take the stand versus take the stand and selectively invoke is actually somewhat ambiguous. I know this has been tried previously in our prior arguments and pretrial proceedings in this case, Judge, but I would argue that my client has in fact invoked her Fifth Amendment privilege, otherwise she would have testified. And I ask the court to instruct the jury not to draw any adverse inference against my client based on that. And that is consistent with 8.01-223.1, which prohibits drawing any inference or penalizing someone for exercising a constitutional right generally in civil cases.
But she didn't invoke her constitutional right in front of the jury, so that's going to be denied. All right, I have no K, so we're on to L, I believe.
Yes, Judge, the party was not impeached. That's generally my position on this. If a party's not impeached, it's improper to instruct the jury on.
All right, so plaintiff had a competing one, you're withdrawing.
Correct. Well, we had a.
Oh, you had the witness.
We had a witness impeachment.
Okay.
We didn't have a party impeachment.
All right, instruction L, she didn't testify, so withdrawn.
Judge, I may have misconstrued this, but I want to clarify. I think this instruction is appropriate because Ms. Werner did testify and acknowledged on the stand that she was not truthful with her clinician. She wasn't impeached through prior inconsistent statements. She is a party in this case. So I think, I understand counsel disagrees.
All of us. All right, you want to?
Your Honor, that's not a prior inconsistent statement. In fact, it's a truthful statement. She said, "Were you truthful? Did you tell the truth to him?" She says, "No." She was not impeached on anything. There's no specific statement. And the language of the instruction tells us why it's not appropriate. If a party is impeached, the jury can conclude that the statement made that they were impeached with is in fact true, rather than the statement they made in court. That's why this instruction differs from the witness instruction. If a witness is impeached, the witness's impeachment can only be taken to the credibility of the witness. It cannot be taken to determine that the statement previously made was in fact true. and the statement now made is now false. And so we had no interaction with Ms. Werner where they said, you said this before and you say this now. That never occurred. And if that never occurred, there was no impeachment by a prior inconsistent statement. And without that, there's no scintilla of evidence to be able to provide it.
So what is the scintilla of evidence you're relying on?
Judge, I just disagree with the characterization of whether or not this constituted impeachment. I think that this was an impeachment of Ms. Werner. She did acknowledge that she was not truthful with a clinician, but that is, reading between the lines, she's acknowledging that she previously made a false representation of someone. That's impeachment by prior consistent statement.
Yeah, I'm going to grant it. All right. All right, next one I have is P.
Object to this routinely. I think the jury is going to be told what the issues are. The jury is going to be told how to find the issues. Telling them just because someone's injured doesn't mean you recover is just superfluous, but I understand it's in the BNJ.
Right, it's a model instruction. All right, I'm going to allow that. All right, Q. That's the gross negligence instruction we've been discussing.
This is the
Their Q.
correct.
All right, any objections? Or what are the objections, I guess I should say.
No objection, Judge.
All right, objection withdrawn. Instruction Q is granted.
Your Honor, I will flag, just, this is Your Honor's preference. We did discuss it in conferral. After the parties are introduced in the preliminary part of the instructions, my preference is, especially if there's only one plaintiff and one defendant, you say the plaintiff or the defendant, or at least shorten their names, because it's going to be a tongue twister for you to be going through all of these and saying all the letters and things of that nature. So that's Your Honor's discretion, but that's something we discussed.
Okay. Did you want to be heard on that?
Just shortening the names is appropriate, Judge. I think that's fine.
Okay, yeah, let's just indicate it, one of the intro instructions that the plaintiff will herein be referred to as, or Abigail Werner will herein be referred to as plaintiff, Dr. Ebony Parker be, referred to as defendant. All right, on to R. Any objection to that? We got competing experts.
Your Honor, sorry, I'm trying to figure out what's modified in it.
Yeah, can Judge
Go ahead.
check me on this? I think it's just a pronoun she versus,
Oh, okay.
I believe, but
That's
please
fine.
double check.
Yeah, yeah. It's just a pronoun modification, so I'm okay with it.
All right, Brandon.
Again, Kevin, if you see something different.
Yeah, I understand.
All right, T. More than one proximate cause.
This is essentially an intro to a superseding cause instruction, Your Honor. There is a multiple proximate causes, but that's in cases where there's multiple parties to assess, and we don't have multiple parties to assess.
You're I'm assuming arguing that there was no superseding cause.
Correct. We don't believe there's been a superseding cause.
All right, but we are offering, there is another proximate cause definition in there somewhere, right?
There's the standard proximate cause that's been agreed to, which says a proximate cause. It just doesn't go into, there may be multiple proximate causes.
All right, so any argument that there is any evidence of a superseding negligence here?
There is, Judge. I would emphasize that for that doctrine to apply, you need not be a party to the action that is a superseding cause. It can be a non-party. This was addressed recently in Reston versus Anesthesiologist. It's a 2025 unpublished decision. And that one's really important because multiple experts testified and opined that the conduct of the non-party physician was, quote, unprecedented, was extremely rare. That's what we're dealing with in this case, Judge. And that's proper fodder for the jury to consider and determine, look, was the shooter, was the 6-year-old child, was that an independent, was that a superseding intervening cause? And so that's consistent, that aligns with the Reston case, Judge. I understand there's differences. I understand that's a malpractice case. I'd also, for the court's consideration, to some extent, the assumption of duty doctrine, it does not subsume the superseding cause analysis. They complement each other. But I've not found a case where it's dealt with, it characterized something as a superseding cause. I would argue, though, in this case, given the unprecedented nature of this and how it aligns well with Reston, that this is appropriate instruction, it's an accurate statement of the law, and it's supported by at least a scintilla of evidence.
You object to superseding cause?
I object, Your Honor.
I'm going to deny that. I don't find a superseding cause exists in this case. All right, you. Yeah, so once again, same objections noted and denied. Objections preserved. W. Now, I know there's competing plaintiffs to this as well.
Clean this one up. I understand the objection to ours because we didn't have the language gross negligence. I presume that that was the objection. So we can include that. The thing that I want to, once we clean that up, this should be permissible. My preference is to split up any physical pain from any mental anguish in two different prongs. That's a difference between the two as well, because those are two, in my view, two separate damages.
All right, but I'm not preventing you from arguing them separately, right?
Correct.
All right, what does the model?
The model has them together, Judge.
Together, okay.
Yeah.
All right, so I'm going to deny that motion. I'm going to do exactly what the model says, but adding gross negligence. So any objection with those rulings?
No, Your Honor.
All right. And I will have asked that defense prepare that.
Understood, Judge.
All right, we have Z.
Is it duty to mitigate, Your Honor?
Yes.
I don't think there's been a scintilla of evidence of mitigation as an issue in this case. Every witness has testified to her diligence. In fact, we've heard a lot about cosmetology school. So I think in this case, the mitigation is not an issue.
All right, any argument?
Judge, I just respectfully disagree. The evidence established that Ms. Werner may not have been forthcoming with the clinicians about some of her medical history.
Right, and then she went to cosmetology school. All right, I'm going to grant that over plaintiff's objection. But it's otherwise a correct statement of the law, correct?
Yes.
Okay. All right, double A.
Your Honor, I don't think that there's been a pre-existing condition issue in this case.
I'm assuming you're referring to PTSD.
I believe there was evidence of that, Judge.
I think there's evidence that she had been previously diagnosed with it.
She had a history of depression and anxiety, Judge.
Right. But it doesn't specify one. It says a pre-existing condition.
But I think we need to address, I think you have to address the totality of the instruction in that context. And she may recover from the aggravation and from the increased severity or difficulty of the treatment, but she is not entitled to recover for the pre-existing condition. We don't, again, there is no evidence from the defense as to what that pre-existing condition is that we are seeking to seek recovery for. Our expert acknowledged that she had a history of depression and anxiety, and that she had new onset post-traumatic stress disorder. And then you have all the physical injuries, of course, which I don't think are disputed.
Judge, if I may,
Yes.
plaintiff's counsel has the obligation and burden to establish their damages. Their own evidence established that Ms. Werner suffered from some pre-existing underlying conditions. The jury is going to be asked, counsel has said, it's like appraising a diamond. You're going to have to figure out how to assess, attach a dollar figure to her damages. If the law here in this instruction tells them, look, if you conclude that any of this condition, any of her damages arose from a pre-existing condition, you can't recover for stuff that falls within the ambit of this work. So I think it's perfect.
I think it was valid testimony, or testimony that the jury could find was true, so I'm going to grant that. All right, AB.
I mean, I think it's a fine misstatement, which is we have to prove gross negligence. I think it's redundant, but
I'm going to grant that. All right. AC, definition of gross negligence.
it's just a modification, Your Honor. So we have a competing instruction on this. That's
Yes,
full.
you do. I got it.
And ours is verbatim to the VMJI.
All right, so it looks like you added some case law and wanted to add quotes. Is that correct?
It's model plus, Judge, and I can speak to why that's appropriate.
All right. Yeah, I'm gonna deny defendants grant plaintiffs.
Judge, may I just be heard for the record? I'll be very brief. I think that it's important. Ordinarily, model instructions fairly cover the issues, but it's not sufficient in this case. I think that the language that's used in the definition of gross negligence is not the way ordinary jurors talk. Nobody knows what slight diligence or the want of even factor. No one talks like that. No one understands what that means. The second paragraph, the standard for gross negligence is one of indifference, not inadequacy, comes straight out of the case law interpreting the definition. That's crystal clear. That's how the jury can make a decision in this case. I'd ask, Judge, if you refuse this instruction, that in closing argument, counsel be permitted to argue to the jury and explain that this is the gross negligence standard, because that is black letter law.
Well, I mean, you can make your arguments,
Thank
but
you.
I'm just not going to instruct them as to that.
Understood.
Okay.
I would just say you can't tell them what the law is unless it's in the instruction.
Right. I mean, but they can say that the evidence that they proved matched what the law is, or
100%.
what the instruction is. All right. Instruction AD.
Plaintiff has a duty to exercise careful decision. This is just our
Your objections to it's a
both. It's also modified, and I'm not quite sure what the modification is, but
First sentence.
what was that?
The first sentence is the only modification.
So it should, the VMJS says contributory negligence is the failure to act as a reasonable person would have acted for her own safety under the circumstances of this case. First sentence should go out, it's not in the VMJI. And then for the...
You're arguing no contrib.
I know, and we're arguing no contrib in this context, Your Honor.
Okay. So I'm going to overrule the plaintiff's objection to contrib. I do think there's evidence to support a jury and an argument as to that, but I'm going to ask that it match the Virginia model jury instructions.
Understood, Your Honor.
All right, objection noted by plaintiff. And that also goes for AE. I want that to match the model jury instruction over plaintiff's objection.
Thank you, Your Honor.
And for what it's worth, I believe that one does comport with the model. I'll double check that.
Okay, I think it does too. Well, let's see. Just besides the gender. Thank you, Magnolia.
I'll double check that.
All right. AF.
Same objection, Your Honor. It's still on the issue of contributory negligence. I understand it's a correct statement of the
It
law,
is,
but I'm
okay.
preserving my objection on contrib.
All right. Allowed. Objection preserved. All right. AH.
I think we have a model competing.
All right, let me see. What does yours start with, Mr. Benyon?
Defendant Ebony Parker is not required to have anticipated or foreseen the precise injury.
Yeah.
Mr.
That's how it
Benson.
starts.
All right, I do find that.
Kevin, you might be able to show us what it is. Mine's Model Plus. So,
Ours is model, theirs is modified.
So agree to model.
All right. Any,
I
Go
could
ahead.
just streamline the argument, Judge. Mine is model, but for the second paragraph. The second paragraph simply adds and clarifies that this is a gross negligence standard. If there's a proper and appropriate instruction elsewhere that instructs the jury on that, then that's sufficient.
okay, I'm gonna deny defendant's grant. Plaintiff. All right, defendant's AI.
This is the finding instruction. I think if we ought to just mirror it to Your Honor's instructions earlier as it relates to your instruction A.
Okay. You just have the 2 prongs, they have the 5 plus the 2.
Correct. So it should just be 2 for us, 1, 2, 3, 4.
Okay. And defendant's objections noted, consistent with my prior rulings, granted plaintiffs. All right, I've got an AJ.
AJ, this is the Pullen v. Nickens issue, Judge. Pullen v. Nickens. I don't know if you prefer to be heard by us or them first.
Let me read it. Okay. So this is defendant's offer. Did you have any competing, or you?
We don't have a
Okay.
competing.
All right, I will hear then from defendant first, then your response.
Judge, to begin, this instruction is informed and is consistent with the court's ruling on the prior motions in limine. Before trial, the defense moved to exclude any reference to the handwritten policies or internal safety rules and procedures. And the reason was largely because case law is firmly settled that doesn't establish the standard of care or the existence of a legal duty. The court, I believe, held that this can be offered for other purposes. Case law, there's a Riverside case which is cited right there that says it can't be admissible if offered for other purposes. If you do that, I ask the court that impose also couple this instruction. I mean, if the court did that, then a cautionary instruction would be appropriate to make sure that the jury doesn't construe this for some inadmissible purpose.
All right, any response to that?
Yes, Your Honor. I think first, I want to say it's inapplicable, and for the reasons we stated in our motion and limine argument on this issue. Godsey and Pullen both involve situations in which a corporate defendant had created standards and policies, and then those were being used against the corporate defendant who made the standards and policies to say that they were negligent by breaching those standards and policies. The evidence in this case does not reflect that. The standards and policies that have come into this case, into evidence in this case, were not created by this defendant. And if they weren't created by this defendant, then this case law is inapplicable to the issue in dispute. And then if we go on to the next issue and say, okay, well, what can they use it for, even if Your Honor finds that Pullen and Godsey are applicable here? The language, the language that says those written policies and procedures do not establish the governing standard or the existence of a legal duty in this case, I think is an impermissible statement of the law, which is that all this information is pertinent to the determination of the governing standard of care. In fact, their witness said so when she talked about we had redirect and testimony about what does somebody do with a tier 1, what does somebody do with a tier 3. There was questions about what are the appropriate standards if they're written in the school context, and so.
So here's what I'd like you to do then. I would like you to draft, I understand you're objecting to it, draft a competing one that meets what you're saying. And I think we can do that. Both sides will object, that's fine. But I think if you could draft one with some language that you believe is appropriate based on what we've heard in this case, I'll consider that at this time. So I'll withhold that for Wednesday. Okay. But I do think it's appropriate to tell them that. It's a matter of how we tell them. All right. So this is to take up Wednesday. Okay. Obviously, on the separate verdict forms that were offered, the same objections based on the court's earlier findings. So at this time, with leave to modify based on anything that happens Wednesday, I'm going to deny the defendants and allow the plaintiffs.
There are some in the plaintiff's
Yes.
version that haven't been addressed.
Correct.
I know you've got somewhere to be, so.
That's my agreed. Okay, so I've got 5, I think. All right, so the first, and I'll just go through what I have, and then you can correct me if there's anything we're missing. First one I have, if you believe from the evidence that a witness previously made a statement. Okay, standing on that? Correct. All right, and you have an objection to that?
I don't. I think it's just because of the other related instruction.
All right, granted. All right, negligence is the failure to use ordinary care, model instruction. Any objection to that?
That's our proffer, Judge.
Judge, our objection is related. This is tethered to the other instruction that's derived from Chapman. I think it would be inappropriate to instruct the jury on simple negligence where the issue here is gross.
Well, we're going to do both, so we'll read, I'm going to overrule that. We'll read negligence first and then gross negligence. Okay. I'm going to note right before gross. Okay. Burden on the plaintiff is, the burden is on the plaintiff to prove greater weight of the evidence each item of damage. All right, it's a model instruction. All right, objection to that?
I'm sorry, Judge. I'm not on the same page. This is their recitation of the 5 prongs for damages. 5 factors for damages.
No, this is just each item of, this goes before that one. This one says each item of damage she claims to prove that each item was caused by the defendant's negligence. It's not required the exact amount, so on.
I think it's model.
Okay, granted. All right, several acts of negligence is the Chapman instruction. Several acts of negligence which separately may not amount to gross when combined may have a cumulative effect. All right, that is derived from case law and your position.
My position is this, Judge. I think that 2 points. First of all, that case law, I just want to be clear, and I would propose that I be allowed to draft a competing instruction that refines this a little bit. Why is because the Chapman case, yes, it did hold that where there's evidence of multiple acts of simple negligence, in some circumstances, a jury may infer that that amounts to gross negligence. What that case law, including Howard, which built on that, what that case law it does not say is that I don't want the jury to misconstrue that law as saying in any case where there's multiple acts of simple negligence, that equates to gross negligence. That is not what the law is. The law.
So you want leave to basically draft a competing one based on my other rulings I've already made?
Correct, Judge.
All right. I'm going to allow them to draft a competing one, and we'll talk about it Wednesday.
Yes, Judge.
All right, and then last is I have when a public official could reasonably foresee that she would be expected to take affirmative action to protect a specific person or class of persons from harm, that public official owes a special duty to exercise reasonable care for their protection based on burns. Right? You want that? All right, your position?
The court has ruled on this.
I'm going to agree. I'm going to deny that based on my prior ruling. So
Just incorporating prior arguments.
correct. All right. Not plaintiff objects. All right, did I miss anything? I have everything else as
I think we're good, Your Honor.
agreed to. All right, hallelujah. All right. Thank you very much. And I believe that concludes the matters we can take up today. All right. And what I would ask is, based on my rulings, if you two can talk tomorrow and try to get a set of jury instructions in the order you would prefer. I do reserve the right to reorder them based on my rulings on Wednesday on the other things we're talking about. But if you can't agree on the order, then just give me two separate, based on my rulings, the order that you prefer, and I'm going to redo them anyway, so it's up to you.